you raise it in the formal session. It's 9 o'clock already. Let me welcome you, honorable members. The minister who has just spoken and apologized, DG and the team, I don't know, the curators who are going to brief us on the municipal councillors pension fund. I was looking for their specific titles, but I'll still get that along. Let me welcome them. Let me welcome any other person who might have joined our meeting for whatever reason, officials both from the department and parliament, and any other person. Let me welcome you and indicate that our meeting slightly packed. We've got 3 items that we need to discuss before 1 o'clock today. So because of that, I will not make any long statements in welcoming you, honorable members. Let me ask for formal apologies, Portfolio Committee Secretary.
Good morning, everybody. Chairperson, we received apologies from both deputy ministers. They would be attending the Cabinet Committee meeting. And then Honorable Buthelezi, she's still off sick until the 28th of March. And then Honorable Beki Hadebe will join the meeting later. Thank you, Chair.
Thank you very much. Maybe from members now, if there's anything that I need to note from your side in the form of apologies. Maybe you are going to leave. Maybe you are going to leave early or whatever.
Yes, Chairperson.
Honorable Minister.
Just like the deputy ministers who are attending the cabinet committee, I would like to be excused to attend the cabinet committee, but I've asked for early departure there so that by the time you discuss the item of the Disaster Management Act, I will be present. So I'm asking to leave now, but I'll come back at that time if it's in order.
I've already indicated outside the meeting that we note that we accept that. And I think the member who was indicating he was not so firm that you should not leave the meeting, but I will allow him. Once.
Yes. No, allow me to be firm, Chairperson. I was proposing that perhaps because we have perused the presentations and we have prepared, to allow us to then ask the questions that are relating to the minister. There are not many questions, it's just clarity. There are probably 2 questions. And then the minister can leave quickly because we've done our homework. We were sitting here the whole night and then you find the minister having to leave without those questions having posed, because it's not only the issues on the disaster management.
No, we note without getting into details. You see, what we may not know is the minister will help. What we may not know is when she is expected to be part of that. But if the DG, in principle, as a committee, we agreed to say the minister, DG, deputy ministers can lead their delegation. They are supposed to respond to all questions, but I don't know, minister, without...
No, I I'm humbly asking to be excused because I am needed in that cabinet committee. Thank you.
Thank you. Honorable Teza, using my position now as chairperson of the committee, I release the minister. If there's anything, we'll take note of that and see how we manage it. Minister, you are released.
Thank you very much, Chairperson, and thank you to the committee. Thank you.
Honorable members, apologies have been accepted. The agenda itself has got 3 items. The first item is briefing on the Municipal Councillors Pension Fund. The second one would be deliberations on the Disaster Management Amendment Bill. And the third one would be consideration of allowances for the commission. So those would be the 3 items, and they are very difficult to time to say this is how much time would require. So the best is to get to them. But let me get a proposal from members in terms of this, adopting this agenda, or if there's any other issue that we might have been leaving out. Honorable members, any proposal for adoption?
I propose the adoption, Chair Kaba.
Honorable Power propose. Any seconder?
Seconded, Chair.
Seconded by Honorable Mbumza, and I see no objection. I would now like to welcome, as indicated already, the presenters who are going to help us to understand the issues related to the Municipal Councillor Pension Fund. I'm informed that Mr. Juanito Damons is leading the delegation. Let me welcome you, sir, and say you would be talking to members of Parliament for the Portfolio Committee of Cooperative Governance and Traditional Affairs. But I see Honorable Mbumza's hand is up.
No, it's a legacy hand, Chair.
It's a legacy. It's fine. No, thanks. Can I now hand over to you, sir, Mr. Juanito Damons?
Thank you very much, Chairperson. I hope my camera is on, because I just want to put my camera on so that people can see who they're talking to. My name is Juanito Damons. I'm one of the 2 appointed curators of the Municipal Councillors Pension Fund. With me is my joint appointee, Pepi Kakana. And then with us on the call is Elias Madige. He's our acting public officer. And Mkuve Ravura, he's a director at RWL Attorneys, and he's been assisting us with the fund throughout. He's also one of my partners. We're going to give him the opportunity, Chair, if it's okay with you, to run through our presentation. We did send a copy of the slides through to you, but he can just summarize it. Everything is in the slides, and then we can deal with the questions. Pepi, myself, Elias, and Mukuva Ravura after the presentation or after the next presentation when we have the agenda item. But before I want to hand over to him, if it's okay with you, Chair, I just want to thank honorable members for giving us this opportunity to come and talk about the MCPF. I think it's been more than 2 years ago that we had an opportunity actually to brief any committee of Parliament on where we are and where the fund is going. Thank you, Chair.
Thanks.
Mukuba, can you put the slide on? The slides on?
Thank you, Annette. Morning, Chairperson of the Portfolio Committee, and morning to the members. I'm just trying to share the presentation, and with your permission, Chair, if it comes on, please just alert me. Is it on?
Yes, it's on.
It's on.
It's on, but there's noise at the background, Chair.
Is there? Are you happy now with that background? Okay, you can proceed.
Okay. Thank you, Chair, for this opportunity, as alluded by my senior, the curator, Mr. Damont. We, in fact, have sent this presentation to the members to go through before we even present, but I would just like to talk through quickly on the points, some of the key points in this presentation. I'll just touch on a few aspects as shown there on the table of contents, but the most issues that I'll dwell on are the points of interest. Just as a background, Chair, you'll remember, and some of the members might have started as councillors in local authorities, that this fund has been there. In fact, it was established back in 1988. It has been assisting councillors throughout, and is actually associated with all municipalities within this country. The fund was initially a defined contribution, but it was then changed. Councillors participate, and municipalities act as employers. And it is actually a saving plan for councillors who are saving, so that when the time comes, when they go on retirement, they actually have some form of money to sustain them moving forward. This is a plan across every industry, even with members of parliament. You have your own pension fund and so on. So it's exactly that, but for local authorities. Now, of interest is that in December 2017, this fund was placed under curatorship through a court order. And the reason behind that order was because the authority was of the view that there was non-compliance with legislation and regulation, and also there were fruitless investments that were made, which the authority was of the view that it is not in the best interest of the members. Hence, they went to court, and the court agreed and placed the fund under curatorship. Now, ever since then, the fund has been managed and has been under the control and guidance of the curators who are within us today. Now, ordinarily, this fund belongs to members themselves. It is run by members. Each province will nominate one trustee to form the 9, and there will be one that comes from now the employers organization, which is SALGA, and there will be 2 independent trustees. That's when everything is normal. But because now there is curatorship, the curator stepped into the position of these trustees. So where we are now, it is only the trustees, and we don't have a board. And of interest, Chair, this fund has been self-administered. It administered its own self. Now, with the appointment of the curators, they came to ensure that certain things or governance must be in order. You can see on the slide there that there have been an establishment of proper accounting systems within the fund itself, the governance and legal communication, administration, audit risk, distribution of death benefits, as well as the investment committees. We can report to the committee, Chair, that all these governance structures are working properly. And it has ensured that the fund now, despite being under curatorship, is able to carry out its mandate. Now, as at October, just before the elections, the fund had 5,286 members, which is over above 50% of the councillors that we have in the country. And its assets, as at October, were sitting at 2.6 billion. If I have to read the number, I'm sure members can see the number, but it's 2.6 billion. Now, on the point of interest, Chair, one of the main issues that led this fund into curatorship was an investment which we like to refer as the ISAHO investment, wherein the fund went to purchase land, but this land was never transferred to the books of the fund. So it was as if the fund paid money and they never received value for money. That was the biggest thing that led this fund into curatorship. Now, when we came into board, we had a lot of litigation with the associated company, which was ISAHO. We took them to court, but ultimately, we can report to this committee, Chair, that we recovered 120 million. That money was paid back into the fund, and the money throughout then has been invested or was invested in an interest-bearing account for the benefit of members. And Chair, we can report that because of the exiting of members following the local government elections, members are now receiving the benefit. When they are paid out inclusive of the recovery, which is this 120 million that was recovered from that bad investment. And I just need to highlight here that this was 120 exclusive of VAT. Now, another thing which is a point of interest was the creators noted that some of the things...
Exclusive of what? I didn't get that one, Chair. Sorry.
Which was exclusive, excluding VAT.
Excluding VAT. Okay.
Now, another issue which was of interest was when the curators were looking into the affairs of the fund, they realized that certain issues, including the manner in which the ISAHO deal was entered into, had some elements of criminality, if one is to put it that way. And this issue was then referred to the Hawks for investigations. If I remember quite well, Chair, at some point there was an IO who was investigating, but there were internal changes within the Hawks themselves, and a new IO was appointed. We are aware, as the representatives or as the officials who are now accountable for MCPF, that there have been people who have been called in to give statements by the Hawks. But it is unfortunate that this is still a very active investigation, and we can't be then naming so-and-so has been called, so-and-so is fingered to be a suspect or so on, but these investigations are still proceeding. We, in as much as we are there as a fund, we can only go to the Hawks and say, what is the progress? What is the progress? So the last progress we got was there have been people that were called in for purposes of giving statements, and they did go give statements. And even the IO contacted the fund. He was requesting certain documents, which documents were provided to them. So where we are now, we just know that the Hawks investigation is still proceeding. Another point of interest, Chair, is an issue involving a law firm, which at the time was assisting the fund, was the advisors. Now, we looked into the amounts of money that were paid to this law firm, which is MSMM, and we are of the view that these funds were exorbitant. We then filed, there was then a complaint filed with the Accounting Authority for Lawyers, which was then the Law Society, but now it is the Legal Practice Council. Now, what happens there is, if you are complaining about the fees that a lawyer has charged you, they will then sit and assess those bills. And if it is found that that law firm is overcharged, then there will be an order that law firm...
Chair, sorry for disturbance. Can the curator read what is he presenting? Can he read what is here in this presentation here? The fund had filed what, and what is he saying is the same thing?
So you are asking that say, you have given us a report. So she's saying go through that report.
Chair, I can read. I was just trying to explain, but I can just
I'm
read.
saying, Chair, he must read only this sentence so we can be able to see if we are in the same page. Because what he is saying is not what is written here.
My fear is that, Honorable Mkalip, if you keep on coming in when he is talking, then our progress might not be. Hence, my understanding was that he must say what is written here.
Yes, Chair.
So if you are saying that, but the disruption might delay us, let's allow him to continue, and at the end, then we'll be free to ask questions. Okay, proceed.
Okay, thanks, Chair. I'll just read then. The fund had filed a complaint with the Legal Practice Council. The complaint was premised on the fees charged by MSMM Inc. as legal cost. There were delays in having the said fees assessed by the Legal Practice Council. However, we received communication from the council that the fund should first pay security prior to fees being assessed. The requested security was 1 million. Through engagements with the council, we requested the security to be reduced. The security was reduced to 390,000. The fund is still of the view that the requested security is exorbitant. Moreover, there is a possibility that out of the assessment, there may be a recovery or there may not be a recovery. Therefore, it is very important to consider whether to proceed with the fee assessment process. The fund instructed its legal representative to seek a legal opinion on the prospects of recovery prior to taking a decision on whether to pay the requested security. We have since received that opinion regarding the prospects of success in the recovery for legal fees. The opinion cautioned the curators from proceeding with the fee assessment process. This was based on the fact that the requested amount for security was still high, and further that the fund is now in possession of a fee agreement which was between the fund and MSMM Inc. Just to move on, Chair, following the local government elections, there was now a project which we refer to as a bulk exit project. That's when we pay out members who have not been re-elected. Now, as can be seen on the slide, as at yesterday, the 28th of February, there was a total exit of 3,431. The claims forms that were received by the fund as of that date, it's 2,631. And of these claims, there are forms that are not completed fully or completed without supporting documents, which stands at 335. And the correct forms, which were completed, everything is done, was 2,296. This 2,296 is includes claims that have been paid and those that are awaiting payment. And as at yesterday, the full number of councillors who have exited, who have been paid, stood at 2,025. And those awaiting payment, where everything is in order, it's 271. Now, Chair, in proceeding with this curatorship, there are measures that have been put to improve the situation. Regarding investment, the IPS, which is the investment strategy, was reviewed. The fund now, as it stands, the fund is fully Regulation 28 compliant. We have diversified the assets by appointing additional asset equity managers, which is Magent, Prescient, Investec, as well as Sanlam. And the fund has been showing an average, or has been showing positive returns on an average for the last 6 months. Chair, again, with regard to compliance, the audit on the annual financial statements for the period ending 30 June 2017, 30 June 2018, 30 June 2019, as well as 2020 and 2021 was completed on time. This is just to show the interventions that the curators have done. Even with the audits, they have been done in time. The above were submitted to the regulator, which is now the FSCA, within the prescribed timeframes, which now talks to the compliance, Chair. And Chair, the fund is required to have a statutory evaluation, which for this fund was as at the 30th of June 2021. The interim statutory evaluation report confirming the financial soundness of the fund was provided by the actuaries. Furthermore, we are engaging with the actuaries to finalize a final 3-year statutory evaluation report. And this would be for the period that ends 30 June 2021. Now, coming to the benefits that members have, with the interventions of the curator, we have ensured that there is timeous issuing of benefit statements to members. There was the funeral benefit, which following affordability assessment, the funeral cover benefit has been improved from 20,000 and it's now sitting at 40,000. And this was done at no cost to the members. We also had a housing facility. This facility had been withdrawn because of issues of non-compliance and non-payment by members, but we have managed to reactivate this facility for the benefit of members. As and when we are talking now, members are utilizing these benefits. Chair, we also ensure that there is member communication. I mean, prior the bulk exit project, prior the elections, we have been engaged with HR and salary personnel on MCPF administration processes. We held various member engagement sessions across the country, and we continue to have member meetings throughout the country. We get invites now and then, and we go to the members, we go and talk to them, and we go and give them an update on where the fund stands. Now, the payment of benefits. We have been ensuring that the fund continues to pay the benefits on time. We have reduced the backlog in relation to death claims. Currently, the only death claims that are remaining in this fund stands at 56. And we also ensure that where we are having a challenge with tracing members, we have now, with getting members, we have now sourced assistance from tracers who then assist us in tracing members so that we can pay the benefits. Now, just to talk slightly, Chair, on some of the challenges that are faced by the curators, one of the biggest would be non-compliant by municipalities. These relate to Section 13A of the Pension Fund Act that talks to the payment of member contributions towards the fund. When a member received his salary, his payslip saying so much was deducted, but we have not, as a fund, received that contribution on behalf of that member. Another thing, Chair, it's unfavorable markets in relation to the disposal of the office park. And that has been a challenge as well. And we also have a challenge in relation to collecting of area rentals. These are properties that are owned by the fund, wherein they were leased out, and some of the tenants were not paying. So we are trying to get them to pay. Some of them have run away. So the collection, it's in a way having its own challenges. Now, Chair, the slide, this just show how we communicate to members. We have regular newsletters. We have an MCPF e-services, which is in Copen. We also have a mobile app that members are well aware of, that they use to communicate with the fund, they use to get their benefit statements. We send out SMS notification. We also have a website which has all reports that we publish. And we are also on social media to be ahead of the time as well, where members can interact with the fund. If members, this is what we put for members when they want to come physically to the fund. That's the address wherein they can come, and they will find the PO there, they will find the administrators there. If they have issues, they raise the issues, and those issues will be attended to. And finally, Chair, this slide just shows the contact information of the PO, the marketing manager, the curators, as well as myself. Yeah, I think that's the end of my presentation, Chair.
Thank you very much. Honorable members, I'm not sure if there's anybody who wants to say anything. The person who introduced you, would you want to conclude?
Chair, just thank you very much. We don't intend to have the fund under curatorship forever. When we were appointed by court, as Mkuve quite rightly pointed out. And at that time, we made an undertaking to the FSCA that we would finish this project within a period of at most 4 years. But then COVID happened. And we just faced huge uphills, and we were not able to, and decided that once we finish with the bulk exit process, we will sit down with all the relevant interested parties and map out a way forward in terms of getting MCPF out of curatorship and having an administrator in place that has the necessary skills and experience to take the fund forward, instead of having a situation where we have a self-administered fund once again, and we may just face the same problems in a couple of years' time. That was the only thing that I wanted to add, Chair. If there's anything, Pepe, from your side?
Nothing, Chair. Nothing, Chair. Nothing, Juanito. Everything was covered. Thank you.
Oh, thank you. Then, honorable members, that is it. Now I'll be taking your hands, raise questions, comments. I'm still trying to, I was trying to say my list here. I can see many hands, yes. Honorable Kalipi. No. Yes, it's Honorable Kalipi, number 1. Mandlenko Sisitelo, number 2. Honorable Grunewald, number 3. And then there's another one with FYA. I don't know who is he, and Honorable Teza. Number 1, 2, 3, 4, 5. Tezans, number 5. Honorable Space, number 6. Can we come in that order? Honorable Mkalipi.
Thank you very much, Chairperson. And thanks for the presentation, Chair. Chairperson, I would like to mute my video because of the obvious reason of load shedding that I'm having here where I am, but I just want to show my face so you can see that I'm not in the bedroom. I'm working.
Nice, fine.
Thanks, Chair. We welcome the presentation. The reason why I was interrupting a person who was doing the presentation because he was not reading what was on the presentation. So I think we must be taken serious because we are dealing with the serious issues that affect people, especially ex-councillors who are still struggling to get their pension fund. And one of the reasons why they don't get their money as expected is because of corruption. So that's why today we don't have Board of Trustees. That's why court took a decision to place this matter under curatorship. So we are expecting those people who are taking over from the Board of Trustees also to take us serious, especially as committee members of this committee, because we are doing oversight here. And secondly, we are also serving the interest of the poorest of the poor, especially the unemployed. Those councillors are now unemployed. So nevertheless, Chair, I just want to get some clarities. First of all, on the background and history, can we also be clarified, maybe not by the presenter, maybe the department will also come in and try to clarify some of the issues. Originally, a defined benefit fund but has since December 2000 has been converted to a defined contribution fund. So can we also have that kind of a clarity to why is that? So we can, when we engage here, we can engage with the clarity. The second part that I would like also to get a clarity is under the background and history as well. It says there here, all municipalities participated in the fund. And it further says that all provinces, which are 8, have nominated 9 people. So it means 1 person per province. So therefore, it must not be just an obvious reason that we will understand as the members of this portfolio committee, how does that process went. For instance, in case and there are 54 municipalities, can we be taken through how does the process unfold in order to have these 9 people who can serve on the board, although the board is not there because of the court decision. But it will be helpful for us just to know how does these members get elected out of 278 municipalities. And we are told that all municipalities have participated in this fund. How is the process of electing those people in order to avoid this problem going forward as we find ourselves? And it further says that the reason behind the curatorship were, amongst others, non-compliance with legislations, regulations, fruitless investments. But we are also not taken into consideration, into confidence, which are those legislations and regulations and fruitless investments. Only the one that is mentioned here, which is the one that purchased a land in Matlosana. And again, Chair, we are not taken into board and told as committee members that now you discover that no, there's corruption that is happening here, but we are not told how much was that land. But we are only told that no, we have managed to recover money from that Isago, which is 120 million rands. But we are not told how much was the land paid for. All those are the details that we need to know. And you are not even told, after you have discovered that no, in fact, the investment involved a purchase of vacant land in Matlosana Northwest was not receiving a value of the said property. So that is corruption. What are the consequences? Who are the people who are involved in that thing? So now, if I was hearing him correctly, a presenter was telling us that now the councillors are being paid from this recovery of 120 million rands. I just want to get that clarity. Are we saying that the councillors are getting their money through this recovery, or am I not getting it correctly? Because if that is the case, I think we are having a very serious problem. Because from the beginning, we were told that this fund is about 2 billion, 2.6 billion. So now these ex-councillors, they must wait until we get that money that was committed into a corruption. I hope that is not correct, Chair. And again, the curators referred certain issues, that is the investment surrounding Isago. And there was a delays on the side of the Hawks. I'm sure there will be a presentation from Hawks here. But delays how? Why? Who was seized with the matter? Because now this matter is coming to this portfolio committee because of the overseas residents, that there are ex-councillors that needs to be paid. When you go down to the presentation, Chair, we are told that total number of existing confirmed members not re-elected is 3,431. Claims forms received as of the 28th February, which is today, is 2,631. Claim forms received not fully completed at 335. Can we give in the breakdown? There are councillors who are still complaining to us as today. There's no communication. When I was listening to the presenter, he was saying confidently they are in touch with former councillors. There are councillors which are confirming as of yesterday that they have not yet heard anything from them or from anyone regards to their pension fund. So can we get a breakdown of provinces or municipalities here? It will be easy for us to, and then we must be assisted. If we have councillors who are complaining to us as members of parliament, for instance, in Swan, I've already have 2 councillors in Sapaling, I have 2 councillors, and in Umzenyate, I have a councillor who also, I don't have anything from anyone updating me when I'm going to get my money. So to get this half-cooked report of numbers without an actual breakdown, without knowing which councillors are still waiting for this money is not going to help us, Chairperson. So for now, Chair, let me just pause there, and then I hope colleagues will take where I left off. Thanks very much, Chairperson.
Very much. Before I allow, it would have been Honorable Groenewald after you. Now there was a hand that I could not read properly. Now the Secretary has informed me that we have been joined by Lieutenant General Libya from the Hawks, is also on the platform. So I thought I should clarify that. And as indicated, I think, you see, General Libya, I am new. I'm a new chairperson of the Portfolio Committee. I may not be part of a follow-up on some of the issues that are happening. So I think we'll give you some space to, because I can see your hand, it would help the members if you speak before them so that we don't continue to talk about issues that you might have helped us to clarify. But if also you want us to ask questions before we allow you to say anything, but I would suggest let's allow you to say something before I allow all members to continue. If you don't have any problem with that.
Good morning, Honorable Chairperson and Honorable members. Otherwise, my hand is not up, but I can introduce myself. I am Lieutenant General Libya, as the Honorable Chairperson have indicated. I am accompanied in this platform by Major General Moodley, who is currently the acting Deputy National Head of the DPCI, in the absence of Lieutenant General Musigidi, who is currently on study leave. His permanent position is the component head of serious corruption investigation in the DPCI. Also on the platform is Major General Mboto. He is the provincial head of the DPCI in the Northwest. We called him to join as we believe that the matter that has been discussed result in his province. I'm also having Brigadier Matruos. He is the section head responsible for government fraud. We called him as the fund will obviously be forming part of those entities that are investigated by this section. He is resorting under the component head of serious commercial crime investigation at national level. Is normally the one that goes to various municipalities when we talk about clean audit, national clean audit task team. Those are just the introductory remarks, Honorable Chairperson. I will leave at that, and then maybe when an opportunity comes, we will explain our position. Thank you very much, Chairperson and honorable members.
Thank you very much. Thank you also for introducing the team you are with. I'm sure as members ask now, they will also know that you are also here. Honorable Groenewald, can we proceed?
Thank you, Chairperson. Chairperson, please excuse me as well with my camera. I'm on the road as well, so if I break up, please excuse me for that. Chairperson, firstly, thank you for the presentation of the MCPF. Just two questions, and Honorable Kalipi also touched on it, is in terms of the Matlusana, can I say project or investigation that there is in Matlusana, what was the total amount that the property was bought for, and what was the value of the property? And then secondly, Chair, in terms of the board is nicely constituted, and they gave us a presentation on that, where there's a member of SALGA as well. The first question is, why isn't the board being held responsible, firstly? And secondly, why isn't SALGA holding their representative on the board also accountable for what happened in a fund? Thank you, Chair. Let me pause there.
Okay. I was also informed that there's an new alternate member of EFF. I did not acknowledge him earlier. Honorable Matumba, now I can see your hand is up. Can I allow you to speak?
Yeah, thank you, Chair. When I went through the report, when it was given, I am really of the view that this is not a full report. We must get a proper report, because this report doesn't give us a full picture of what is happening in the Municipal Councillors Pension Fund. Firstly, Chair, if you go to the number of exits confirmed, you'll find it's 3,431. But confirmed forms received is 2,681. Now you have 800 councillors. Their forms are nowhere to be found. So it means these councillors, they are far away from getting paid their money as we stand. We don't get any report as in what is the fund doing in order to assist those councillors. Now, even those who submitted their claim forms, you still have claims in the process of payments, 271. These people exited last year. Now we are coming to, we are in March, still they are not paid. So this is simply telling you that in terms of administration, the fund is extremely poor. Now they will tell you about their offices being found. They gave the location of their offices. But when you call, it's something different. These people are working from home, and councillors are at the mercy of administrators. It's a saddening situation, because most councillors are now in debt because of this fund. Now, we also get a report that there is communication with members and HR. Now, you ask yourself, if there is communication with HR and members, why do we have outstanding 800 forms? So it means there is not that communication that we have been told there is communication. Statements. The issue of statements, it's another issue, because if I can give example with my 5 years of saving as a councillor, I only got my statement once. So the issue of having statements is something else. But let us go to what we want to see as members of parliament. We want to know the liquidity. How much do they have as a fund? How much do they have? If all councillors that are affiliated to this fund, if all of them are to resign tomorrow, is this fund going to be able to pay them? The other thing, Chair, is that they are saying the main problem that they are having, they face, is the reason behind curatorship, where amongst others, non-compliance with legislation, regulation, and fruitless investments. That is untrue. This report is trying to manage Parliament, because they know that they themselves, they have referred matters to Hawks, that there is theft, there is corruption, there is fraud. And these are the things that they are not writing to us. SALGA proposed that this fund be merged with political office bearers pension fund. We want to know how far are they with that, because councillors are also office bearers. Lastly, Chair, I will propose that can we please, can they please go back and write a proper report, a report with full details, because if you had the previous member of parliament when she was articulating it, she even showed that there are many details which are not here. Lastly, Chair, let me remind you that the curators of VBS were the first to say VBS doesn't have liquidity. They assisted those who invested in VBS. Now, in this situation, we want the same. We also want to know how much is it costing us when this investment is under the curatorship? How much are we paying them compared to what we were paying those who were taking care of this fund? Because we don't want them to take care of this thing forever. They are just curators in and out. Thank you, Chair.
Thank you. Honorable Space.
Thank you, Chairperson. Good morning.
Good morning.
Chairperson, just the following questions. Just maybe latching onto the last speaker, is that I wanted to find out the curators, they being reimbursed for their services, and I want to know what does the reimbursement amounts to in terms of a breakdown. I've heard also that the non-compliant municipalities, I think it is the arrears is to the amount of 89 million. I need to understand what action has been taken in terms of collecting these arrears from municipalities. Then there was mention made, Chairperson, of housing facility benefits. I would like to know what exactly this housing benefits includes. And then, Chairperson, there was a mention made of 5,286 members belonging to this fund. And it was very confidently said, but if we look at the amount of councillors in this country, it's not a good indication. And then on top of that, 3,431 of those 5,286 have already filed, are actually leaving, have left the municipalities and obviously put in claims. So which means there's not much left, not many members left in the fund or remaining in the fund. I must say, Chairperson, there's a lot mention of newsletters and communications. I've looked at the forms of communications from the fund itself, and I must say that out of a membership of 5,286, their social media pages is only followed by 600 people, and their last posts were last year. So well done to communication. Gone on the website, also not so informative as being stated. So we can get reports of what is happening, but we actually do engage with councillors and we actually go look at these things. So, Chairperson, for me, there is a huge concern in terms of a number of issues, and we have received, as I said, long presentations, but the reality on the ground is not like that. I've engaged with a councillor that has also belonged to this fund for many years, and she's having huge challenges in getting her pension payout. It's not I'm not surprised, Chairperson, because I've been a councillor uninterrupted for 11 years, 15 years, but uninterrupted 11 years. I've never had a desire to join that fund. And in a way, I'm glad I didn't. So, Chairperson, can we have all these questions answered? And can we get a realistic report of what actually is happening, and not something that is trying to impress, a report that is trying to impress us as members of this committee? Thank you very much.
Thank you. Now, Honorable Kaba. I can see you, Honorable Teza. I skipped you. I don't know how it happened, but let's take Honorable Kaba, and then I'll come back to you.
Can you put Comrade Teza, because I have a problem here.
Okay. No, it's fine. Honorable Teza.
Chairperson, thank you very much for the opportunity to speak. My first question, very quickly, you have a report that talks about 5,286 members payment of the non-returning members. Now, you have 257 municipalities across the country and councillors across political lines. How much of these councillors do we have outside of this fund? And why is that? Because, Chairperson, why I'm asking that, the Remuneration of Public Office Bearers Act requires that the relevant municipal council to make pensions contribution for the duration of the councillor's term. As such, municipalities are expected to establish a municipal pension fund for the municipal councillors, and the minister to set annual limits for the contributions by municipal council to such funds. So I'm asking in relation of that, is the fund itself compulsory? Because we are all public representatives, whether you are representing the people in the local sphere of government, the province, and national, you are the same. So why should other things be compulsory and others be compulsory in Parliament, like permit, and others not compulsory? Because currently, Chairperson, the councillors across political line, all of them do not have food on the table. For over 3 months, there have been delays. Honorable Nkalipi told the committee that we are inundated with a lot of complaints from councillors who have not been paid. So we would like to know all those questions from them. And then, Chairperson, the COIDA 61 of 1997 also provides that an employer must register all employees with the Commissioner for Compensation at the Department of Labor. What action has been done to ensure that everyone is compelled to join the fund? And in fact, what is the money? What would be the contribution of the municipality? Because on section 4 of the local is to establish the fund, and then for a person scheme for a benefit of its councillors and their dependents. Now, how is the council going to make sure that actually they also contribute? How much is contributed in that because it's not clear how much that is coming from the council. The other question is, I didn't get how much is the interest. I just knew that there was interest that was recovered. And then the other question pertains to preventive measures. So how are we going to prevent? Because in the interim structure that has been appointed by the court, which is the curators, what are the preventive measures that the department will put in place to preempt fraudulent and corruption action when a new board is appointed, what will be the preemptive measures? And then Chairperson, for they are talking about self-administration. I'm interested, Chairperson, what does it mean for the fund to be self-administered, and how does it compare to a fund that is not self-administered? So you have that situation of non-clarity throughout the presentation, and we are not quite getting joy out of it. And so I'm together with all the colleagues of the committee when they say that they must go back and clarify. There are no municipalities that have been mentioned. There are no provinces in terms of how the fund seeks to remunerate councillors. Thank you very much.
Thank you, Honorable Mbumza.
Thank you, Chairperson. Am I audible?
Yes, yes. Yeah,
thank you very much, Chairperson. Chair, let's welcome the presentation by the curators. Mine, Chair, without repeating, I think my colleagues had covered me in a number of areas. Mine would be that what remedial action is the curatorship bringing in on non-compliant municipalities who are in arrears? Linking that question also that the administration was supposed to be a period of 4 years so that they exit that. Now that also they saying that that hasn't happened as a result of the advent of the pandemic. Now, what are currently the timelines for the curators to suspend their administration of the fund and bring it back to the Board of Trustees? The fund presented here of 2.6 billion. Can we be told exactly, is it really growing? If indeed it is growing, by what ratios is it growing? Because to me, that figure, that figure of 2 billion has been around for some time. To me, it should not be seated in that particular regime at this particular moment. I think Honorable Space had covered the other question that I wanted to raise then. Thanks very much.
Thank you, Chair. Now I see no further hand now. We are supposed to get responses, but I think in the Mandlenkosi. Mandlenkosi Stelo, yes.
Chairperson.
Yes.
Chairperson. Yeah, it's Mabiga. It's appearing there as Mandlenkosi. I don't know why. Chairperson, you noted me so early. I don't know why my name was not being recognized for quite a long time.
Hand that disappeared from this part. I'm giving you the platform.
Oh, I didn't know I had to
raise your
put my hand up because you have noted me already, Chair. So I thought by then you just called the list as you had read it out. I'm not going to open also my video, Chair. My connectivity is very poor. I'm covered in most of the areas where I wanted also to raise some clarity-seeking questions. But the one that I'd like to raise also, it's around the accessibility of the fund. Honorable Speaker has also mentioned that it is said the fund is in all the municipalities in South Africa, but the membership is only around 50%. I just wonder if that makes them feel comfortable to say they have achieved what they wanted to achieve. So as I said, I want to ask around accessibility. If they are above 50%, what is it that they are doing to ensure that members do join this pension fund in their numbers? Because I believe that the reason it is there is to help the members out. It's to benefit the members. So they should be looking for 100% of all the councillors in South Africa. So I wonder if it is accessible enough to councillors. And also, I would love to know if they have got a breakdown of their members to say, out of the 278 municipalities that we have in a country, each municipality has this number of councillors affiliated in the fund. But I just want to believe that this fund is not being sold enough. I just want to believe that some of the councillors are not aware of this fund. And that is why they have got such a low percentage of the membership. But I think they can comment around there as to how far do they go in ensuring that most councillors are being informed about the fund, though it is known that it's not compulsory for councillors to join it, but maybe some of the councillors are not aware of how beneficiary it is, how helpful it is to be part of this fund, and such that I'm not sure if the information that we have been given about the curatorship and the likes, if all the members of the fund are aware of all this information, if they do have a platform to communicate with their members to say, it's where we are right now, this is what is happening. One other member spoke about the amount in the fund itself. And the other one spoke about even the statements that councillors don't even receive statements to update them as to how much they have accumulated in a fund, let alone recruiting members to join the fund, so that when they leave the municipalities, they are able to benefit. Thank you, Chair.
Thank you. Sorry for that omission. We are now through, but before I allow the curators to respond and their team, as earlier indicated, we have got Lieutenant General Libya here from the Hawks and his team. By implication, because I was asking whether they were going to make any presentation, or are they going to respond to some of the questions? But it looks like there was some communication breakdown. So I would allow him to clarify their presence and what could have happened, so that we take off at the same level and understanding. Lieutenant General.
Thank you very much, Honorable Chairperson and Honorable members. When we received the invite, it indicated that we are to be responding on the Municipal Councillors Pension Fund. The information was sketchy at the time, and then our presentation, unfortunately, dealt with the National Fund for Municipal Workers. So as a result, the presentation that you shall have received is talking to a different fund than the one that we are supposed to be focusing on. At the same time, it would appear that the matter was brought to our attention in 2017. And then indeed, it would appear that it was reported at our Section 34 report, where the person who received may have been placed at another environment, which means that the presentation that we currently have before you, Honorable Chairperson, is not going to assist with the current questions that you are seeking clarity on. We would then request that we be given either an opportunity to go and respond in writing, or maybe we invited at a later stage when we have got the information put together for the purpose of answering the questions. We have picked it up on the notice of motion last night when we received this presentation from the colleagues who have just presented, that there was indeed a motion when they were getting appointed as curators in 2017. That is where we are picking up the reference number. So that is the position that we are at, Honorable Chairperson. We do not have the presentation that answers to the question, but if given an opportunity, we will be able to prepare for that one. Thank you very much, Chairperson.
Thank you. No, that helps us so that we don't get, I think obviously it would be up to you. We'll have to, I think we do require the Hawks to come before us. I think even in relation to this issue, where we have got a question about this land, but it will not help us if we say respond now when you have not prepared. So obviously, we'll definitely offer you that opportunity to come back and prepare for it. We can't ambush you and say, talk to issues that you have not prepared. I'm speaking on your behalf, members, but I would want to hear a voice. I'm a Democrat. If there's anyone who would want to suggest something. Can I hear you, Honorable Groenewald?
Thank you, Chairperson.
Yes, I've noted Honorable Mkhaliphi and Ezra.
Thank you, Chairperson.
Okay.
Chairperson, yes, thank you for the general. But Chairperson, I think we have to engage. So for the general to come back in writing, it won't work, but we can do it multiple to say that he must respond in writing as well, and then come on a later stage and do a presentation so that we can engage on the matter. As he said himself, it's outstanding since 2017, and we're already at 2022. So it's a 5-year later, and we do not see any action or progress. So please, we must engage in terms of that. Thank you, Chair.
Honorable Mkhaliphi.
Yes, Chair, I agree with my colleague here that no, it will be unfair to General Lebeya. as he was putting it very clear that he will need sometimes to come and do justice in the committee. And I think we must grant him that a proposal, Chair, so he must come back with a very prepared presentation, because this is very serious. Chair, thanks.
Thanks. Lastly, Honorable Teza.
No, agreed, Chair, because from their presentation, they have two issues only. The issue of Renosterbeck and the other issue. So I do not think that some of the issues will be done justice that we're asking the curators here and who are interested in as a committee. So I think that a prepared report will be necessary. Thank you.
Okay, no, thanks. Then Lieutenant General, I think there's agreement to say it's up to you to remain, but you will obviously get some communication from us to indicate when do we want you to come back and what would be the issues. Otherwise, thank you very much for coming. I'm not releasing you unless you have got something pressing that you must attend to. The country is burning. We've got these serious issues that talks bad about the country. So you are allowed to remain, you are allowed to leave, it would be up to you. Can we now allow the curators and the team to respond to the questions that were raised?
Thank you, Chair. I think my colleagues and my joint curator will come in. I've tried to make notes as much as possible to actually deal properly with the questions. But just before I start, we're trying to respond to some of these questions. It must not be seen that we are not taking engagements like this very seriously. We were invited last week to attend this session this morning. And we've been working over the weekend to try and get everything and everybody involved together to attend this session. So we take it very seriously, Chair, in terms of what is expected from us. I hear from all the questions, there's a lot of detail that a lot of the honourable committee members require. Maybe we won't also be in a position to answer every single question and deal with all of the detail in this meeting. Surely we have the detail. We are required on a bi-monthly basis to report to the FSCA, which we do every second month. That report goes onto the FSCA website as well. And we are duty bound to report to the court on a yearly basis on where we are with the curatorship and where we're going. And that is a very, very full and detailed report comprising of many, many pages. So if we don't get to all the questions, we would also request from our side that maybe we be given an opportunity to get into the detail, because we understand now what the honourable members from this committee actually expect to see in a report of this nature. I don't know, does that, or do one of my colleagues want to jump in on that before I start, starting with Honourable Mkalipi, starting there to answer questions. Pepe, is there anything you want to say, or Elias, or
Juanito, thank you. I think some of the questions, especially about, how municipalities work before our time, I found that some questions referred to before, the curatorship. Elias should be able to respond to. Thank you.
Okay, yes, Sis Pepe, I was going to do that. Maybe, I don't know if you want to go first, then we can jump in once you are done with answering. Then we
yes,
can just
Elias, I think the first question from the Honourable Mkalipi was a question around the background. and why the fund changed from a defined contribution fund, and why the fact that all of the municipalities involved in appointing, involved all of them in appointing the board. And then those are things that happened before our time that we can't actually respond to.
Okay, I can perhaps you need to do that. And thank you, Chair, and good morning to the honorable members of the Portfolio Committee. My name is Elias. Yonito and Ms. K are my principals. I'm the acting principal officer for this fund. So on the question, the first question by Honorable Tlengyom Kalipi, on the background, she wanted a clarification as to why the fund was initially a defined benefit and then later on in 2000 was changed to a defined contribution fund. So the reasoning behind that, it is because we know that not the local authorities or the municipalities are independent autonomous bodies who independently over and above the allocations they receive from the National Treasury, they generate their own income.
The recording has stopped.
Hence, you would find that no, there are those municipalities who are self-sufficient financially, so, and then those municipalities who solely depend on the allocations they receive from the municipality. So by a defined benefit, it would mean if a member or a councillor has exited a fund perhaps 10 years ago, that employer being municipalities will continue being liable to pay that councillor a pension fund up until the certain time whereby a member passes on also or carries on. So it was resolved that no
recording in progress. This meeting is being recorded.
That arrangement of it being a defined benefit will not work as it is currently working with the GPF, being the Government Employees Pension Fund, where we know that no, the members will get monies up until I don't know how many years later after they've left the employee, and then they use a certain formula to say that you were earning this much, and then for this number of months, then that formula will generate a figure which they will give you on a monthly basis. So with a defined contribution, a member receives at the end of the term what they have contributed to the fund, all of it plus the returns which they received from the market. I believe Councillor Mkalipi and honorable members, it answers your questions. And with regards to how is the board members...
Maybe I'll be a mayor, not a councillor now. Maybe when I come back, I'll be a mayor.
All right, no, that is fine, that is fine. So the board comprises of 13 members, 9 being elected by members from all 9 provinces as per the presentation, and then 2 is independent and 1 is from SALGA as an employer body. So how are members from the provinces end up being in the board of trustees? So we know on a yearly basis, the provinces itself, they convene the provincial members assembly, whereby they discuss issues of concern per that province. So after a 5-year term of office has ended, we know that also the members or the board of trustees term is limited to 5 years. So after on the 5th year, there will be an election run within that province where all the municipalities, they will convene, and amongst themselves, they will nominate 1 member, irrespective of whether there's 55 municipalities per that province, but they will join forces and among themselves, out of the 55 municipalities, nominate 1 person to say that, no, you will be our rep in the Municipal Councillors Pension Fund. So that is done by the members per that province. So they do it on their provincial members assembly on the 5th year when they are having an elections. It's an item which they will normally put in their provincial members assembly to say that no, now we need to elect a member who's going to be serving in the Municipal Councillors Pension Fund because the new term of office for members is coming to an end. Then they need to be a new board member. So that is basically how it works. In short, Honourable Mkalip, and the properties I I think Mukobe has already said that no, we recovered 120 million rand from there, but the amount which was paid way back in 2015, when those 12 properties were bought, they paid 120 million rand excluding VAT. So the amount which ended up being paid to the ISAO at N12 company was 137 million or so. I believe some of you might have seen it on the reports, but following the processes which were done by the curators, the only amount which can be recovered was the capital amount of 120 million rands, which was excluding VAT, like Mukobe has already alluded. And then that money was invested, and then there was an interest and on that, and subsequently that money was reallocated to all the members who are belonging to the fund. And as we can speak, some of them have already been paid that portion. We've paid the ones who have already exited even way before the local government elections, and then those ones who have passed away, unfortunately, we are tracing their beneficiaries and paying them. And then also the ones who we are in the process of paying, their amount is inclusive of that amount. And then the breakdown per province of these bulk exit stats, we've thought about doing that, but then we ended up just putting a summary of all the exits we've put there. Those stats can be made available in the report, which members were saying that no needs to follow as well, and we need to also say that no, we can do it in writing. So lately that one is easy to do. We can, by the time we do this report, maybe we will not even be having any pending payments. We will be saying that no, zero pending payments. We've paid everyone who needs to be paid. And then Councillor, Honourable Member Groenewald indicated how much was the properties. I've answered that. And then why is the board not being held accountable? I think the general from the Hawks has already answered that question. And then the question about Salga, why are they not holding people accountable as well? I think they can answer for themselves on that one. And then Honorable Matumba says, full report, that one we can still do it and we can follow it up on that. Mukobe and myself and the curators will compile a detailed report and submit it to the committee or to the secretariat of the committee to disseminate the report. And then the number of exit confirmed, the honorable member indicated that no, from his calculation, there appears to be about 800 unaccounted exits. And what is the fund doing about it? Believe us when we say that no, we know that there are those municipalities or those members who have not submitted the funds. The exit forms to the fund for us to pay them. The reason there is I wouldn't say we know why, but the conclusion we're having is that no, those members themselves, they are not in a hurry to submit the forms as opposed to the other ones. Like I, as an exited member, I know I have got a money in the fund. We've got those other members, even from the previous terms, who have opted to leave their benefit within the fund. And then we cannot be chasing and say, here's your money, where is your form? If the member chooses not to submit the form, there is a decision of the member. Their money is not going anywhere. Their money will remain in a fund and it will remain invested and it will earn interest and returns up until that members take a decision to submit the forms. And once we receive those forms, we process those payments. And with regards to the ones we've already received, we've seen that no, 90% of those forms in 2025 have successfully been paid. Yes, we agreed that no, there were some delays with some of them, of which we have engaged with members to say that no, maybe your ID is not visible. Maybe you did not give us a correct text number. Maybe you forgot to sign this page. And all those things, they cause delays. And we've taken ownership of those mistakes and say that no, our role and our responsibility is to ensure that no members get paid. And then those 279 or so odd, which are still pending payments, some of them, they've got issues, like I've indicated. Some of them are clean and straightforward. we are in a process. There's a batch or batches created for today's payment, so that those batches are going to come from the 279 today, and then that number will obviously be reduced. The liquidity of the fund, or as well, you said you wanted to know how much that the fund has, and then if all the members were to resolve to exit the fund today, we will be in a position to pay all of them. The answer is yes. When Mugabe was doing his presentation, he spoke about a statutory evaluation, which is a process required to be done by pension funds. So that process, we are required by law to do it every 3 years. And following that 3 year, we do it interim per year to see, to determine the financial position of the fund. The last one, which was done, was in 2018. Subsequent to that, we done 2019, 2020, and 2021, which is said that no, there has to be another statutory evaluation report for as the period as at the 30th of June 2021. That report is due to the regulators 12 months after the time, so it is going to be due this June to the regulator. So the interim one, which was done last year, confirmed the previous interim report, or even the previous 3 years statutory evaluation report, to say the fund is in a sound financial position, meaning that each and every single one who wants to, if they were to say, all of us, give us our money today, we will be in a position to say, okay, wait, here's your money, all of it, and then without fail. So the fund is in a sound financial position as per those reports. So you also said that no, there was a proposal by SALGA, of which we are aware of, to join the funds. This has been discussed at various meetings where we went, like we said, we've been engaging with members in all the various provinces. They will say, why are we joining this fund with the municipal, with the political office bearers pension fund? So maybe SALGA, perhaps if they are in a meeting, they can answer that question for themselves, and then the curators will answer the questions about their stipends and all that. And then Councillor Spice, or an honourable member Spice, apologies to say, Councillor, you said, what have you done?
Sorry, Chair, Spice, not Spice.
What have you done with the issue of area contribution of about 89 million rands? So this is linked to the issue where we reported that no, various municipalities are non-compliant with regards to payment of contributions and all those other things. So the question was, what is it that the fund has done? We have engaged with the municipalities themselves. We've reported the same to the Financial Sector Conduct Authority. We are also required to be reporting them to the police and all those other things, of which is the process which we had planned to do this year. But this 89 million rand, just for the interest of the for the benefit of members, is mainly a historical matter, whereby we would know that the fund, hence we said it started in 1988. Some of these things, they've started way back in 2008 when the fund was managed, but you said you've been in the fund for 11 years or 11 years or so, so you know that there was Muriting, APSA, Akani, and all those other things. So these other things were done by those. So we went to go and check who are these members and where are they seated. So most of them, we found that they are no longer even councillors at this point, but then their contributions, which ought to have been paid by the municipalities, formed part of this 89 million rand. So it is not practical now to say that no, because these members were already paid what they have already contributed in a fund, because this fund is a defined contribution fund, to say that no, if you contribute for 3 years and your term of office is 5 years, you are going to get out of the contributions for 3 years. That is what you have contributed plus the return. So obviously then this area contribution started growing and accumulating and all those other things. Then it ended up being this. But the majority of these former councillors, I call them former councillors because some of them, they have passed on. Some of them, they are no longer councillors. Maybe they are in the employee somewhere or in the parliament. But then just a mere fact that no, their contributions were due when they were still in, it also forms part of the book of Section 13A of the fund, of which we cannot just write it off without consulting all the relevant persons. But most of it is impractical to recover, to be honest with the honorable members. But then the current ones which are currently in the system, the ones we are aware of, we have followed up with letters of demand. We have entered into settlement agreements. Now there is this other one of Alfred Duma. Sorry to mention names. Yeah, we are in engagement to say that no, you let your members choose to not contribute, but now we're having this situation. So how do you resolve it? So the offices of the curators are dealing with that legally. So we are rest assured that no, some things are being done with regards to these non-compliant municipalities. And then also, you indicated that no, there are huge concerns with regards to a number of issues. I believe most of them I might be aware of, or maybe I didn't get which real concerns are those, but then the ones of which we are busy with, and then the ones which the one I'm aware of is when members will say that no, I've been waiting for my contribution for so long and so long and so long, ended up taking us to the pension fund adjudicator, and at the end of the day, only to find out that that member has been paid already and the proof has been provided, and then the member says, okay, apologies, is resolved. So those are the kind of issues which we as a fund, we are exposed to from members who have been paid, but then they ended up saying that no, we are not being paid. So we are aware of that. There are a group of councillors, and not only in Gauteng, but all over, they will say that no, please know that I have not been paid, telling the other counterparties to say that I have not been paid, but only to find out that member has been paid. So we don't know how to resolve that. Those are the things which we are not aware of, which we are not in control of, but then those ones which we are in control of, specifically with regards to these pending payments, which are 279, which we have forms, we are paying, and the ones which we do not form, we cannot pay because we don't have forms. And then, honorable member, as I said, how many councillors do belong to municipal councillors pension fund? And he also indicated that no, is the fund itself compulsory? I would say yes, the fund is compulsory. The pension fund itself is compulsory because on the determination of upper limits for councillors, it says the members need to join a pension fund. It does not say specifically which fund, but then you as a member or as a councillor, you need to go and join a pension fund, and then it is for the members' benefit. We know that no, there are those municipalities who are not compliant by enrolling their members into any other pension funds, but then hence we say that no, some of those things we are outside the MCPF's control. And then how many members the stats were put there just prior to bulk exit, which is about 55% of the total population of councillors in the country. So you said the employer are compelled to register everyone to on the Department of Labor. I received a query yesterday about this. I said no, I'm not aware of that. Maybe they need to check with the employer themselves, whereby a member wanted to go and claim an UIF as well. So this one, I think the committee, it falls within your mandate to ensure that no, that is enforced. And also the interest, it gets compounded on an annual basis. It will not be the same as last year's interest. The last year's interest over and above the challenges of COVID, the fund returned a positive 5.7%, which varies on a monthly basis. Some months will be negative, some months will be positive. But at the end of the day, we cannot say how much interest. We can just say this year it was this much, that year was this much. Then we average it and tell you within a 5-year term of office, this is how much the fund was able to manage to return for members. And then the other question is, you wanted clarity on what is a self-administered fund. So a self-administered fund, basically what it means is the fund itself puts systems and processes itself to manage its own operations, as opposed to having other pension fund going to seek services of the third parties to come and do the fund operations. By fund operations, we mean processing of the debt claim, processing of members' benefits, updating of members' contributions, member communications, and all those other things. So there's been comparison which was done, and you need to mention it when Mukobe closed his presentation to say that no, various lessons were learned, and then some things will need to be implemented as to which is going to be the best possible mode of managing the fund going forward. Going to get a third-party person to come and manage the fund, or continue managing the fund as it is, of which those are the decisions which still needs to be taken following all the engagement with all the various stakeholders like you need to assess. So basically what it means, a self-administered fund, is the fund itself has got its own processes and system and its own people internally, which does whatever it is being done by the people there in Old Mutual, by the people there in Alan Gray, or by the people there in Alexander Forbes. Basically, that is what is happening here. The same thing which is happening at that side. And then the remedial cash action on what is it that the curators are doing with regards to enforcing compliance with regards to non-compliant municipalities. So I indicated that no, there are various litigation which has been litigation processes which are currently underway. We've engaged various municipalities whereby letters of demands were sent. We've served letters of demand with various municipalities in the Free State, where some of them came back and said, okay, but now how about we reach a common ground? So we've engaged at length with all these municipalities which are willing to come to a party to say that no. By this, if you are not following this process, at the end of the day, you are disadvantaging members, but you deduct the members' benefit, but you don't pay it over to the fund. Well, what is it that you're doing to these members? So some of them will start contributing, some of them will contribute 3 times, after 3 months, but eventually those contributions will start flowing into the fund. And those ones who are refusing because they are not deducting, or because they are or they've led members to dictate to them over and above what the law is saying, say that no, as an employer, you are not allowed to let an employee or a councillor to say that no, can you cancel my pension fund? That is a big no-no, because it lands the accounting authorities in trouble. But then some certain municipalities are doing that, but we are following that in terms of the law. Or the requirements of Section 13A of the Pension Fund Act. So the 2.6 billion rent is growing by how much? I've answered that. And then the last one is Councillor Mantlogos, but I think I got your name wrong, where you said your iPad shows Mantlogos, but it's not Mantlogos. You said accessibility of the fund. To me, it was more of a comment to say that no, it appears that no, this fund is not being communicated enough to members. Hence, only about 55% of members are belonging to Municipal Councillors Pension Fund. We have various member engagement sessions on an annual basis. There are HR and salaries practitioners workshops which we convene on an annual basis. We go to these municipalities, we speak to them. But remember, there is this. I would like to call it a freedom of association, to say that no, you as a member, you are obligated to join a pension fund, but it does not necessarily say join Municipal Councillors Pension Fund, so long as you are a member of the pension fund in terms of the determination of upper limits, to say that no, you can prove that no, I have joined, then you have complied. So I know some time way back there was a time when almost 80% of the councillors belong to the Municipal Councillors Pension Fund, and then also all these other issues which brought the fund into curatorships are really not helping. But then as we've reported to this morning, and as we have reported in various platforms to members, there has been a various huge progress and improvement in the fund. The confidence of members is coming to, it has increased tremendously. There are those the members which are still flowing in the fund as we speak. I can say that no, there's a lot of things, a lot of work which still needs to be done. So we can do one thing at a time. But then the most important thing is that no, the fund is still operational. Payments are being made. Members are being paid. We're receiving complaints. We're receiving queries, and then we're taking all the punches. And at the end of the day, we end up. Members end up being paid. Hence, you will see that no, almost 90% of all the claims we've received have been paid. So the rest of the others which I have not answered, I think my principals will answer to that. Thank you so much, Honorable Chair and Honorable Members.
Hi, Honorable Chair.
Yes.
Can I just add a few things? I think Elias has answered most of the questions, but can I just come in and try and answer some of those questions that he may have missed?
Yes.
I think just to emphasize, I think it was the Honorable Kalipi who just mentioned the issue of that she was concerned that councillors were being paid recovery monies and not what they actually entitled to in terms of their contributions when they either are not re-elected or retire. I think Elias cleared that up. Councillors are getting what they're entitled to in terms of their contribution. Over and above that, they are getting paid the portion that they are entitled to in terms of any recoveries that we make. And how the portion is calculated that they are entitled to from recoveries made, we actually have our actuaries that does that exercise for us to determine what each councillor is entitled to from any funds that we may collect. I must admit also from Honorable Nkalipi that our systems and everything is not what we would want it to be. The situation isn't a normal situation. The MCPF is under curatorship. And it makes it difficult sometimes to deal with certain of these aspects, especially there, as we mentioned before, where we are required to make decisions around using funds. We're entitled to, and it may answer some of the questions that were asked later about what is the fund being paid. The fund is a self-administered fund. Since our appointment in about 2017, we have not changed what the fund charges members to administer the fund. It's 6%. 6% per month on the contributions that we receive. We use those funds to fund the fund itself, which has approximately 19 employees. We use those funds to pay the curatorship fees, and I'll get to that detail now, because I know that's a question that Honourable Spies asked about, what the curatorship fees are and who's paying us. So out of that percentage, we pay our staff, we pay PAYE, we pay for all the other operational expenses, and we pay the curatorship fees. We had a unique situation when we were appointed as curators. Pepe Kakana is an acting judge. She's a senior attorney. I'm also a senior attorney. Both our hourly tariffs, which at that time was 3,500 Rand per hour, was kept at 2,000 Rand an hour. That's all we are entitled to charge. I have in my office, for example, 3 attorneys, including Mukuve Ravura, who made the presentation. At Pepe's office, she's also got a full-time attorney that works on MCPF matters. We are not entitled to charge more than 2,000 Rand an hour for any of them, despite seniority. And over and above capping our, and this is the agreement that was reached with the Financial Services Conduct Authority, because at the time they were having serious problems with curatorship fees and members' contributions being used to pay curatorship fees and expenses. And so they kept our monthly fee as well. So besides having our hourly tariff cap, which hasn't been changed in the last 4 years, we also have our monthly fee capped to 450,000 Rand for both our offices. Our bills are sent to the FSCA every month on the 3rd of the following month. They then have 10 days to scrutinize our bills, and only when we have their approval are we then entitled to pay ourselves. Although we are court appointed, this is the arrangement we made, and it was in the interest at the time of the fund. So that deals with how we are paid, how the fund manages to pay its staff and its operational expenses. And I can say up until now, and I can say this, we have not used one single beneficiary, apart from the administration fees that we are entitled to, and that any other fund, whether you give this fund over to a Sanlam or to any other fund, your members will be obliged to pay administration fees. I think we are the lowest, Elias, and you can confirm with that in the industry. But that is what it is. What it is. The fund is under curatorship, and we have to live with it. Then I just want to get, I think the issues of self-administration was covered. The issue of exiting. Yes, we did say the exit discussion that we had was the exit discussion in terms of what we thought we could achieve over a 3-year period. Because of the litigation and some of the other issues that we're trying to sort out in the fund, and I mentioned the COVID situation that we had. We anticipated that maybe 3 years was a correct period. We're now in our 4th year, and looking at a time period of which will be a reasonable time to exit. The latest is the middle of next year to exit and hand over to either a reputable administrator together with a newly constituted board after consulting all stakeholders, or whatever form it takes that will be in the interest of the Municipal Councillors Pension Fund and its members. That decision will be taken, and it will be a decision that includes all stakeholders that are involved. I don't know, is there anything else that I reported on? I just think, Chair, maybe to do justice to what we tried to do today, is to maybe send through, or if we are invited again, to have a very detailed report that we come and share with this committee. Obviously, we can't share individual councillor information, but we can surely break up the numbers to talk to that in a much more deeper level. Thank you, Chair.
Thank you. That is the response, honorable members. We will allow follow-ups.
Chair. Before follow-ups, Chair, there's just 2 questions that I think my colleagues did not deal with as I was taking them up. Yeah.
Yes, please.
There is a question that related to the non-compliance, or what with this non-compliance. And I can advise members in this committee that it was issues of non-compliance with Regulation 28, and then also the concerns that members had in relation to how they communicate with the fund. They were not getting joy with the fund and the investments. Now, with Regulation 28, it just tells you you are a fund. If you have so much money, you can invest so much percentage in equity, you can invest so much as cash, you can invest so much in property, so on and so on. So the fund was not complying with that. The curators came in, and with their advice, we also got from the advisors, financial advisors who are also assisting the fund. The fund is now Regulation 28 compliant. So that's the compliant issue that I was referring to. The last issue, Chair, it's the issue of statement as well as the compensation fund, although the PO did talk about it. The issue of the compensation fund, in all fairness, Chair, it does not fall within the ambit of a pension fund. That is what an employer does with its employees. Now, a fund, it's just a benefit that emanates from the employment relationship through agreement between the parties. So as to whether a person is registered with the department, that will be between that specific employee and his employer, which is now the municipality. And the last thing was the issue of statements, that members were not getting statements. I can clearly advise members in this sitting that I, together with the PO and others who are not here, we personally go to the municipalities. I remember one instance where we were in a meeting with councillors, and this issue was raised that we are not receiving statements. What we did was just to call and say, where are the statements? And the information we got was the statements are there. They were received by so-and-so in the speaker's office. An official left to go to the speaker's office to check. They came back with a box, a courier box with the statements. And the response we got was, oh, we were not aware that the statements were already at the municipalities. So where we are having issues with statements, the members can call. My numbers are public. They are there on the fund. They are there in the presentation. They call us sometimes, and we escalate. We simply get these things generated from the system, and you can send it. So those are the three issues that I wanted to respond to. That was not dealt with. Thank you.
Why send statements to the municipality instead of the individual members to their emails or post?
Who is speaking now?
It's Honorable Mabika.
No,
Chair,
Honorable
I can't take this thing of sending statements to the municipality. Why to the municipality instead of the members themselves?
Honorable Mabika, please. This is a meeting, so you can't just stand up and speak. I was recognizing hands that I see there. So in a meeting, you indicate that you want to speak, and I give you authority to do so. So I would ask, plead with you, let's not do that. Can I recognize, because they have responded to our questions, obviously there would be follow-ups. Can I recognize the hands? I am not sure, Honorable Teza. I see your hand. I see the hand of Honorable Mkalipi. I see the hand of Honorable Matumba. I assume, because I think there's a problem with the naming of your gadget, Honorable Mabika. I assume you'll then speak after the Honorable Space. I see you. And so I'll accommodate you, Honorable Mabika, as number 1, 2, 3, 4, 5. Can you, Honorable Teza, shoot?
No, thank you very much, Chair. I don't think that we are getting much satisfaction in the responses. Hence, it prompts the follow-ups. I'm happy that the curator is also in attorney, because Pension Benefits for Councillors of Local Authorities Amendment Act of 1991, Act number 16, 1991, Section 3, it says that a local authority which prefers not to establish a pension fund in terms of Section 2 by itself or with any other local authority, or not to enter into an agreement mentioned in the said section with a pension fund established in terms of that section, may, subject to conditions as the minister may determine by notice of in the Gazette for the benefit. Now, don't you think there is a problem there from that amendment? To say that you may decide not, don't you think that the municipalities are quite aware of this section in the Amendment Act of 1991, and thus are not able to compel? Because I hear that you said it is compulsory, and I disagree. Really, based on what evidence are you bringing when you are saying abruptly it is compulsory? Based on what legislation? Because I'm reading a legislation that was amended here. And then you go to I'm reading it again, Chair. The Public Office Bearers Act requires that relevant municipal council make a pension contribution for the duration of the council's terms. Why are some councillors just left to chance to just decide not to have councillors paid or make payments towards this make payments towards this important because given the fact that councillors, it's a very short lifespan of work, politics. You have 5 years and you have nothing else after that. Many councillors are clamoring for their lives, that to get above the water and things like that. They don't have food, they don't have nothing. They call us every day. So based on these two sections, would you not, what is the consequences for non-compliance? And what is the underlying legislative framework that governs the work of ensuring that councils do contribute to the fund and make necessary recruitments in terms of improving on the beneficiation of councillors, because this is beneficial to them. On payments of benefit, you said 56 death claims. You have 56 death claims. Who is tracing the death beneficiaries? And from which fund are they getting paid from? The last question should be, based on what evidence or even observation of any municipality in the country are you saying that councillors are not in a hurry? How many of them are not in a hurry to get their monies, given the circumstances? The other question, the last question, Chair, that was not answered, on corruption. What are the preventive measures that the department is ready to put in place to preempt fraudulent and corrupt action when a new board is set to be appointed? Thank you very much.
Thank you, Chair. Chair, can I speak?
Yes, please.
Thank you, Chair. You know, Chair, in the beginning of this meeting, you also mentioned that we have a tight program, but it's clear that the interest of the members in this item, it's also warranted that we must reschedule this item again, because as Honorable Keza is also saying that we are unhappy because the presentation itself was not detailed. So therefore, I'll appeal to you, Chair, that let us get another chance and to come and engage with the curatorship, because now when I was listening, to responses in terms of the time frame of the curatorship is not clear, and we are told that they were supposed to be taking care of this process for 2 years. Now there was COVID and so on. So we need to know who must facilitate the handover. I don't know if it's the department, because I don't think it will be them as lawyers emanating from the court decision, or is the department itself. So we needed that clarity, because, Chairperson, as I said before, this item came here in the agenda of the portfolio community because there was a challenge in terms of pensions to former councillors. And secondly, Chair, I also asked before to say that there are many councillors who are saying they have not get any communication from the office, from the HR, as the presentation is indicating to that, but they are contacting us because they know that we serve in this committee. I also need to know what is the way forward, because we can't add to poverty. We can't be seen to add to unemployment. Already in the country, there is a high unemployment. So therefore, us as people who are entrusted to represent those unemployed, those people who are swimming to poverty, we must not also just do the lip service to our people. So we need that clarity. After this meeting, we must be clear how to refer councillors to whom, because I am not convinced. I said to these presenters here, in a form of curatorship, can we get a breakdown per province, per municipalities? No one have responded to that, because the core business of this presentation or this engagement is to go back and tell our councillors who are saying, now we don't know what to eat, but there's money that's supposed to help us, but there's no one is communicating to us. I agree with Honorable Mabiga. Why the statement are being sent to municipalities? Why are not sent to individual members? But I'm sure Honorable Mabiga is still going to come and get clarity on that one. I'm just saying there are many gaps that needs to be clarified in order for us to have clear responses, on behalf of the people. The other matter, Chair, that because of time, and I think when we come back again, when we have time, to get more clarities in terms of how to facilitate the handover from the curatorship and how to ensure that the new board of trustees are not going to repeat what the previous board have committed, because we must also ensure that we have prevented those things that are not supposed to happen, because corruption is not going to assist anyone. The other matter is that issue of security. Firstly, we were told that, no, in fact, there was a complaint coming from the curatorship about the security. We wanted to know, what is the status of the security money? Is this money going to be paid back? Or once the negotiations and the agreement have agreed on that money, which is 390,000 from that exorbitant fund, is going to be paid back, or what is the status of it? We need to get all those clarities. But my proposal, Chair, is to say, let us get another chance to come and iron out all those issues. But now we need to know those councillors who are still saying, I have not been contacted. I've submitted all my documents as specification, but no one has contacted me. I don't know. Now I go back, I go to bed hungry. Where can they get that information? And also, I don't know, Chair, how also to deal with this. As I'm here in this meeting, I'm getting some messages from the councillors saying that Egoruleni municipality, the councillors who are benefiting from this pension fund, they are only getting 100,000. And they think that if they compare to other councillors, I don't know what informs that. Maybe if you can get some clarity with how much is expected per councillor to get from this fund, because others are saying, no, I heard from my colleague from Mpumalanga in one of the municipality that no, she or he got 300,000. So can we get that information? How much are the councillors supposed to get? Thank you very much, Chair.
Maybe before we allow the next speakers, let me indicate that I've, from the onset by the curator, they admitted after the questions that their report was not adequate enough to address all this in detail. So I think we noted that by implication, it means they will have to come back with a detailed report, trying to close some of the gaps. But we wanted to continue with the meeting in the sense that where members still want to raise issues, I think this is the last round actually, but we agree that they will have to come back with a detailed report trying to respond to some of the issues we are raising. Can we get to Honorable Matumba?
No, thank you, Chair. Before, let me make it clear that a report and details can cover the realities that our councillors are facing. If you look at the respondent, this small report, you can tell that there is a serious problem in terms of administration in the fund. There is absolutely no relationship between the fund and councillors. The relationship is between the fund and the municipality. And this relationship between the fund and the municipality is not professional at all. You can have a report that comes to tell us that some municipalities hold on to the contributions by councillors and not pay to the fund, and nothing happened. Because immediately, if ever the municipalities keep with a day, the fund must be on top of that municipality and make sure that that money is paid. Now, again, we are told here that councillors are at liberty to choose any institution that they want to invest with if they don't want to come to the fund. Now, one will be right to say this fund is clearly directing our councillors to be exploited by private institutions that are offering the same services. Now, as a point of interest in the contents there, one of the point of interest should be the direction this fund, in which this fund is taking, and that direction is clear. This fund must hand over councillors to the political office bearers pension fund, because by the look of things, there is absolutely nothing that is being done here. One, look at the 800 that I gave, that these are people that their forms are not done completely. We are told that some of them do not want to take their money. We must have that kind of report that tells us that these are the councillors that do not want their money, because councillors out there are crying. I personally know councillors that are in depression because of not getting their money. Now, coming out of this meeting, what do I tell them? Because I don't know whether they fall under those that say they don't want their money, or those that want their money but they are falling in the cracks. Now, lastly, Chair, let it be known that this the curators do not take this committee serious, because they clearly said they do have reports. Everything that we want here, they say we have reports, we submit those reports to the FCA. Now, coming to politicians, they just give us a small paper when they hold a serious report that we must deal with. I think I gave a proposal back then to say, in fact, this item should have been postponed to a later stage, so that they know that we didn't entertain their report at all because we don't have a report. Thank you.
Honorable Speaks.
Thank you, Chairperson. Chair, just two clarifications. Maybe I have maybe not heard, but and maybe it passed me, but I did not get a response on what the housing benefit entails. And then Mr. Diamonds referred to when he was talking about the reimbursements and their hourly rates, he also referred to a monthly rate that is allocated for both offices, and I stand under correction. He mentioned an amount of 450 monthly. So I need the clarification of that, because that means it's about 5.4 million a year. And I just need to understand if I heard correctly, is it 450,000 per month to both offices? Thank you.
Thank you, Honorable Mabiki.
Thank you, Chair. Let me start by apologizing for
command. Honorable Schreiber, the platform is yours now.
Thanks, Chair. I just want to check, how would you do what Honorable Commander
who is speaking now? I thought I asked for Honorable Mabika.
Yeah.
Who is on the platform now? Who else is there? Honorable Mabika.
What I wanted to raise was from the last speaker, who stated categorically clear that they do send statements, but statements are being sent to municipalities. And to me, that is unnecessary. It proves what Honorable Matumba was just saying, that it looks like the relationship is between the fund and the municipalities. I mean, and not with the members that they administering the fund on behalf, because you can't be sending statements to the municipalities, because councillors do not live in the municipalities, and some of them are part-time, and surely they must be having addresses of all the members that they are taking contributions from. So to say and try and argue that they do send statements, I think that is wrong, because with the other pension funds like your GPF, they send statements direct to members, because they want to ensure that statements do reach their intended owners. So if they can consider Chairperson to change their way of doing things and start sending statements to councillors, because they must be having their addresses. It can't be correct to say that they are communicating with the municipality because they don't know where to reach the councillors. Thank you.
Thank you. I suspect, let me repeat that I think we agree that the fund, the curators must come back with their team with a detailed report. It is equally correct. Members got that right. We could have rejected the presentation on the spot that said we want a detailed report. But equally, because of the pressure from the Honorable Ministers, I will allow you at the right time. I don't know how to unmute you or to mute you. Chair, because of the pressure from the beneficiaries, we allowed you to speak. But I'm saying we want that detailed report. So we'll allow you now to conclude by responding to some of the follow-up questions, but would want a detailed report, and the committee is going to indicate when. Over to you.
Thank you, Speaker. Maybe let me just start ahead of my colleagues in terms of the first question that emanated from my last comment. The issue of why are the statements sent to the municipality. Okay, we have to understand that this is not something that just starts now. This fund has been there even previously. And you had members, even when the fund was still under the management of the Board of Trustees, where they didn't have addresses on their forms, they did not have emails, and the manner of communication was something will be sent to the Speaker's office, and the Speaker's office has those small boxes that you find in the municipality for each specific member, that it will then go and be placed there, and the member will go and collect it there. I can assure this committee that ever since our appointment, we have been trying our utmost best to even constitute an email database for all the members. When we go to these municipalities, when we meet with these councillors, we also ask, in addition, give us your emails so that moving forward, we know member X, here's the email. The statement should go directly to that member. But even with that, there are so many challenges. I mean, there's municipalities in Nkandla, there's municipalities in Mukula. Even the way the councillors would even tell you, we don't have emails. So it's not a one-shoe-fit-all type of thing. There are challenges even when it comes to communicating. But where we are trying to see how best can we communicate. We gave now their numbers, we're sending through SMSs over and above the statement being sent there where we don't have an email. We send an SMS that go and check at the Speaker's office. You will find your statement there. So, Chair, the issue of us sending the statements to the Speaker's office, yes, it can move, it can be updated with time, but we have to first complete the process of getting each individual's email addresses or physical address, which we are still doing even today. Okay, there was a question asked by Honorable Gaza, and I'm even, sometimes I wish,
yes.
Sorry. I wish I can go with Councillor, with the Honourable, so my apologies, Kaiser, to these meetings, wherein he's saying we should not allow councillors to be exploited by private funds. Because what happens now, in the past 3 months, we've been getting invites to say, come to the municipality, come and talk to the incoming councillors. You go there, you find the agenda there, it's MCPF, and there are other many pension funds there. And they say, send yourself to the councillors. And you send yourself, you say what you have to say, and the councillors themselves then decide which of this pension fund am I picking as my pension fund. And one of the key selling points is always the fact that, guys, be wary of private pension funds. They are there to make a profit. So maybe when we've got an honorable member with us, I'm not sure whether you'll be marketing for us, but that's the key point that we use as well in this meeting to say, avoid private pension fund because they are there for a profit. Maybe that it will assist us as well. And then there was also a follow-up on the death benefit claims as to who is investigating, who is tracing. What happens with death benefit claims is this is when, unfortunately, when a councillor passes on while still serving as a councillor. Now, there is a risk benefit attached to this pension fund, which now this member will get the 3 times pensionable allowance, and then we will then pay out that money plus the contribution that councillor has made to his or her beneficiaries. We use our administrators, and at times when we're having problems, we also send in our tracers. We have companies that trace people for us to say, go in that family, we need such and such a document, we need such and such an affidavit, and they assist us in getting that information. And where we have that information, we request proof that you were dependent on this member, and then the monies are paid accordingly. Moving forward, Chair, there was an issue, I think this fell from the last set of questions, the housing allowance. What is it? Housing allowance, Chair, in short, it's a benefit. For those members that have been saving in MCPF, they will have a specific amount as their fund value. Now, members have been saying, but I can't even build a house. I don't even have money to build a house. How is the fund assisting me? Then the fund went and spoke to financial providers, banks, to say, can you assist our members? Standard Bank agreed, and out of this, members can go to Standard Bank and apply for a loan, and they get 1/3 of what they hold in the pension fund. But it is important, it is not the fund giving a member a credit. A fund is not authorized to give credit. It's a member going to a financial institution and getting a loan, and the fund stands as surety to say, if something happens, we assure you, Bank X, we will cover those costs because this member has so much sitting in the fund, which we have, and we know we can throw our weight behind this member that they will pay. If they don't pay, we will pay you. That's how the pension housing loan, pension-backed housing loan works. Okay, maybe I'll let my colleagues. Okay, no, that's one question that I want to deal with. How much is expected to be received by members? Members of this portfolio committee, we need to also consider that municipalities are not the same, and the positions that each member holds are not the same. A person who is a mayor in a metro and a person who is an ordinary councillor in a grade 3 municipalities, they earn worlds apart. So that one member will be contributing towards his pension, and a person who's a mayor on this side will be contributing more. So it can't be that the person who's contributing more will get the same as the person who's contributing less. So each member gets what they have contributed plus interest. It can't be that because such and such a member got 300 and I got 100,000. We look, how much did you put inside the fund? At what rate were you investing? And also the grade of the municipality where you are determines what you put. If you are earning 10,000 and someone is earning 50,000, obviously the contribution, the pension fund contribution will differ. So it can't be that a member in Ekurhuleni and we compare to a member in Thulamela, they will never be the same. That's what I wanted to alert. The others, I'll leave to my colleagues. Thanks.
Thank you, Chair. Thank you, Mukobe. Just to add, I think I'm just going to touch on 2 or 3 which haven't been touched. The one of a main concern, which was raised by Honorable Member Keza, I think it's very important. He wants to really know what preventive measures are going to be put in place to ensure that no corruption ever takes place going forward. I think this will have to form part of the next report to say that this is what, obviously this is going to be a combined effort through all the interested or all the stakeholders to ensure that if ever a trustee is going to be put on this place, so what are the processes which will have to be put in place to ensure that the trustee does not repeat the mistakes of the past. So this is what will obviously form part of the report. We are not saying, we are not answering it now, Honorable Member Keza. And then also what cuts across, the the questions from Honorable Hlengyong Kalipi and then Honorable Matumba is the members who are saying they are not being paid. So me as a way forward, because I heard the chair saying that no, we need a way forward to ensure that no, we help these members. I would propose through you, Chair, to say that no, if the honourable 3 members are getting these concerns, our contact details are in the presentation. Let them not sit with them to be discussed in the portfolio committee. We are open, we are accessible. Just send me an email or send me a WhatsApp or call me to say that no, Councillor from Kurudeni says don't know, they've been waiting for so long. So that no, we can deal, we are in a position to help these members there and then. So it's not happy to say they are complaining there, but they are not complaining to us. So we don't know what is it that no, we're dealing with, because we also have got our own query mechanism which we are dealing with. So my proposal is to say, help us help these members by sharing the information they're sharing with you. So by that way, we will be able to deal with these queries. Then if there are any issues which needs to be addressed to the municipalities, they can be attended to as a matter of urgency. I think I've touched on that. Mukobe, you've answered most of the questions, also including the one for housing loan. And lastly, the status of the security. I think it just needs clarity through you, Chair. I'm not trying to take more time of the committee. The Honourable Member Mkalipi, you wanted to know this security assessment, when is it going to come to members? So what I heard from the question is that maybe there is a misunderstanding. So this security, it's a fee assessment committee fee to assess the matter. So with this, within the Legal Practice Council, if you are submit a complaint of a fee from the lead, they take the quantum of the amount you are complaining about. They charge 5% of that before they even consider looking into that matter. So in this matter, in this case, the initial as 5% was going to be just over 1 million rands to say, let's consider this assessment fees before they just pay us 1 million rand before we even try to look into your matter. Subsequently, they reduced it to 390,000, which is not the money coming into the fund. It is the money which needs to come out of the fund, pay it to the Legal Practice Council for them to assess that matter. So there has been legal opinion, Namgobe, saying that no, the legal opinion cautioned to say that no, because of issues of prescriptions and because of the mere fact that there was an agreement between the fund and this law firm, chances or prospects of success there are almost nothing. So it's either you take it or not. You can pay them 390,000. Chances are that no, you will not recover anything from there. You would have even paid money for them to assess, and then you get nothing out of there. So it's not the money which is coming to the fund, to members. It's money which is going to have to come out of the fund to be paid to that agency for them to look into that. So that is the status of that. So a decision has to be taken whether is it worthwhile to pay, while we know that no, the outcome might be negative. So that is where the issue is, Honourable Member. Thank you, Chair and Honourable Members.
Thank you. Now, because I'm managing my time as well, I think we have agreed now that we would expect you to come back with a detailed report. I'm sure there will be communication from the committee as well, just to make sure that as you come back, you understood our message well. I'm sure members will still want to follow up, but we can't allow that now. Otherwise, thank you very much for coming, spending time with us to explain yourselves. And I hope next time it would be the last meeting, so that all of us will go back to our trenches to do the work with a common understanding. Our duty is we are public representatives. And so our duty is always to represent. We also look at some of the actions that ought to have been taken or not taken by those who execute the laws. And lastly, make sure that the public all the time is involved. So whatever questions that we have raised with you, they are informed by that mandate. Otherwise, thank you very much for the presentation. We are not...
Chair, before you close, Chair.
Before I close this one, yes.
Yes, Chair, I wanted to check if I heard correctly what Mr. Elias Msiza was saying in terms of councillors who want information. Is Mr. Elias going to give his information to the Secretary of the committee so we can pass that information of contact to members who wants to know when are they going to get their money?
I think he was saying so. He must give us that information, maybe through the Secretary of the Portfolio Committee, so that we are able. He was saying they might be complaining to us, it might not be getting to them, but they are the ones who are supposed to pay. It also talks to my saying they should come later, but the payments must go on now. So I think there will be that exchange of contacts and whatever. Okay. Can we close the session now, this one, so that we can move to the next and say thank you very much to the curators and the team. See you next time. Thank you.
Thank you, Chair. Thank you.
Thank you. Thank you.
Thank you.
Thank you.
We should celebrate.
Oh, okay. Honorable members, we are moving to the second item of the meeting. And that second item talks about the deliberations on the Disaster Management Amendment Bill, B2 of 2021. It's a meeting that we postponed last time, where we're supposed to take a view on the desirability of the motion. But I think with the people I've been speaking to, they are of the view that it should not just be us voting. We still have this opportunity for the last time before we decide on the matter, to make sure that we understand each other well. Because all these processes, in the end, they are meant to help the citizens out there. So on that basis, and also on the basis of when we concluded last session, we gave out some tasks to the department, ministry, to say what seems to be a gap now between all of us. It looks like there's no longer an issue about executive and parliament in terms of executing the law. We seem to agree that the executive have to execute the law. And what seemed to be a problem is the issue of accountability and oversight. So when I say what seemed to be a problem, it looks like we're not of the same understanding in terms of that. So that needed to be clarified. You said everybody has a homework, so they should go back and look at this, what seemed to be a gap in terms of this current act, if there is indeed a gap there, on the basis of the two, before we can then decide. You said then, ministry, you will have to take us through that to understand exactly what do you see in this thing of accountability and oversight. And obviously, members will then be and in particular, Honorable Funeral, who proposed, without saying raise your hands, would also allow him that opportunity so that we lead this, we want to have this understanding before we can then allow members and after that ultimately take a decision. So that's the approach we want to adopt. Unless somebody wants to advise me differently. So if we agree, we would allow the ministry to take us through this understanding, especially focusing on what I regard as a gap now. And when I say gap, misunderstanding, if you like, on the issue of accountability and oversight, because Parliament obviously would jealously guard the issue of accountability and oversight granted to it by the Constitution, which I also believe the executive as well would jealously guard what is assigned to them in terms of the Constitution. I just thought I should raise those issues and try and say this should be the approach. Then we'll allow members immediately after the ministry and Dr. Groenewald, and then members would come in so that we help ourselves to have an understanding. What is before us is this motion of desirability of the bill. Thank you very much. I'm not sure if the minister is back now, but I can see.
Yes, I am.
Oh, okay. Then welcome, Minister. I immediately hand over to you. You would see how you want to approach the process. Thanks.
Thank you very much, Chairperson. And also greetings to the members of the Portfolio Committee. I think from our side, I'm happy that the Chair is saying the question of the executive has been cleared. And I want to just say a few words, but the presentation will be done by Dr. Dow. But just as an introduction to say that, of course, we don't think this is desirable. But in terms of accountability, we are for accountability and oversight. But of course, the Disaster Management Act, though coordinated by COGTA, tends to affect a whole range of other departments. Depending on the disaster, if it's a drought, it will affect certain departments. If it's floods, depending on what the floods are doing, are damaging. So the oversight has to be, in a way, multidisciplinary. COGTA has to be overseen and accountable, but other departments also will have to be overseen and be accountable. And there's no question about oversight because it's a constitutional mandate that members of Parliament have to oversee. So what I would say is if we think there was the members of Parliament have a right to say how they can strengthen their oversight. But we are not opposed at all to accountability and oversight. We take it's a constitutional mandate and all of us have to respect it. So just as an introduction, but I think Dr. Dow will give a more detailed presentation on our behalf. Thank you, Chair.
Dr. Tao.
Thank you very much, Minister. Good morning, Honorable Chair, Honorable Members, and all visitors to this debate, and all my colleagues. Thank you for the opportunity. Yes, as our Minister has already introduced the matter, I'll be taking honorable members and everyone in attendance through what has been prepared under the leadership of our Minister, and having also consulted other role players, as we indicated in the previous meeting. Just as an introduction, I would like to just state, Honorable Chair, that we have prepared about 16 substantive slides based on the brief that you have already introduced, and which has already been covered at high level by our Minister, and that we consulted few documents that we felt were resourceful in assisting our Minister to guide us in capturing the message that we'd like to convey. And those documents include, but are not limited to, the Constitution, the Disaster Management Act, the National Assembly Rules, 2014 version, the Parliamentary Oversight and Accountability Model, the 2009 version of that, as well as in terms of case law, also considered several cases that were brought to government in respect of the COVID management. I'm now getting into the substantive slides, and I indicated that there are about 16, but I will seek your indulgence, Honorable Chair, not to go into every one of them, because some have already been stated in the previous meeting. This is just the purpose where we respond to the question of desirability and accountability of members of the executive and oversight by Parliament that you have already alluded to. But we conclude as part of the purpose to recommend that the Portfolio Committee approves the considered position that COGTA is tabling, or has tabled before and is reaffirming today, as already introduced by our Minister. Slide 3 and 4 are just a restatement of what is already in the public domain, which is what the private members' bill objects are, which are known, and I will request not to get into that because it's already in your records. And slide 4 talks to also what the bill seeks to amend in the current piece of legislation. Then I'll move to slide 5, which is thus outlining the journey that has already been traveled in respect of the bill since it was introduced to Parliament, and where the Portfolio Committee was assigned the bill in 2021, and written comments were obtained from stakeholders around August 26 August, and there have been 2 sessions, the one of 7th September and the 16th February that precedes the one that we are having today, and during which session, the previous one, the issue of desirability, oversight and accountability were identified as requiring clarification, and that today, the 1st of March, is a date for further deliberation and possible conclusion on the bill. And then we'll go now to slides 6 and 7. These are slides that I can surmise that have already been somewhat covered by the introductory remarks, which
Sorry, Chair, moving. Sorry, Doctor, for disturbing. for interjecting. The slides are not moving at all.
Oh, they're not moving. I'm on slide 6. Let me just unshare and reshare. Hopefully, there will be improvements. Okay. May I check, Honorable Chair, whether honorable members can see the slides now? I'm on slide 6.
Yes, Doc, we can see now.
Okay, thank you very much. Thank you. On slide 6 is just a reaffirmation of what the Constitution already provides, that we all part from the premise that our constitutional democracy provides for state that constitutes of 3 branches, being the executive, legislature, and the judiciary, and that at national level, the parliament is responsible for oversight of the work of the executive. We also allude to section 55, 56, and 57 of the Constitution that provides the founding provisions regarding conducting oversight of the executive by the National Assembly. And we recognize the fact that oversight is a constitutionally mandated function that entails the informal and formal watchful, strategic, and structured scrutiny exercised by legislatures in respect of the implementation of laws, including the making of regulations where an act of parliament confers that power to implement laws, and also issues around the application of budget and strict observance to statutes and the Constitution. We also cite the fact that of importance is that this oversight entails overseeing the effective management of government departments by individual members of cabinet, including those at provincial and local government level, in pursuit of improved service delivery for the achievement of better quality of life for all citizens. We also would like to just single out also the fact that the National Assembly has the right to determine its method of work independently from other branches of state. And once it has done so, it should perform its functions in line with that decision. And that the mechanism for Parliament to conduct oversight of these organs of states and the executive will be through portfolio committees, like our minister is today appearing, the portfolio committee, and of course, the joint rules, specifically Rule 199 to 203. I indicated that we also quoted the document titled Oversight and Accountability Model, the OVAC that is already known to members, a section specifically that deals with asserting Parliament's oversight role in enhancing democracy. And what is important there is that it defines the concept of oversight as the proactive interaction initiated by legislator with the executive and administrative organ that encourage compliance with the constitutional obligation on the executive and administration to ensure service delivery on agreed to objectives for achievement of government priorities, close quote. And therefore, based on that, it is crucial to know that this definition attempts to capture both the ex ante and ex post events. That means the anticipated as well as the post facto events or events that would have already occurred, and further assess the significance of Parliament oversight on the work of the executive. I cited the issue of court cases, and I think this has already come to the committee on several occasions. But what is important is just to underscore that these court cases reaffirm the position that the department or government has taken in respect of dealing with COVID, particularly the application of Section 27 about national states of disaster, 41 provincial states of disaster, and 55 that deals with municipal states of disaster. If I can just cite this one case, the court indicated that the construction of the Act makes perfect sense because it contemplates a situation of a national disaster where regulations have to be made to give effect to containment of harm caused by a national disaster. It could be national disaster, as our minister said, of any type of hazard, whether it's hydrometeorological, it's geophysical in the form of earthquakes, or it's biological in terms of animals or plant diseases and human diseases, as is the case with COVID. And the court therefore concluded that the implementation thereof would invariably have to be brisk or quick in circumstances where the declaration is not permanent. So you can see how agility has to be an inherent element of applying provisions of the Disaster Management Act, especially when it comes to matters of disaster response. This court case also, the same line of reasoning, the Helen Suzman Foundation also, the DA case also, which you already have, honorable members. And then here we just want to respond to the questions about the three keywords, which is accountability, oversight, and desirability. Having considered, honorable members, the proposals and the effect of the bill that the bill may have on the disaster management function, and having considered the court findings and other affirmative cases and the effect of the bill, the DCOC, under the leadership of our minister, provides the following position in response to the task assigned by the portfolio committee. On accountability, we would like to submit the following. The focus must be on the fact that disaster management is everybody's business. That means everyone, all members of the executive are accountable, and that the Department of Cooperative Governance through NDMC plays a coordinating role, and our minister has already highlighted this point. Sector departments therefore have an inherent and primary responsibility to implement the Act through the development and implementation of their disaster management plans to become risk averse, reduce vulnerability, and increase resilience. That is precisely what all of us should be preoccupied with, in that every day that goes, someone is deciding to build somewhere, someone is deciding to build in a particular manner, and there's various hazards that prevail, the locust outbreak in the Northern Cape and other areas. So our main or major preoccupation is what are the measures that are being put in place by sectors to prevent, prepare for, and mitigate any risks in compliance with the provisions of the Disaster Management Act. I believe honorable members are very au fait with the provisions of Section 25 of the Act, which calls for national organs of state to develop and implement disaster management plans. Section 38 and 39 that deals with provincial departments as well as provincial organs of states and other entities, and Section 53 and 54 that talks about municipal organs of states as well as municipal entities that must also develop and implement disaster management plans. We therefore, honorable members, state that as such, those sectors become individually and collectively accountable to Parliament, National Assembly, and not only the minister administering the Disaster Management Act. And I think that the previous input about accountability should be read with the provisions of the Constitution in respect of Section 55, 56, and 57 as already cited. Now we go to oversight. Parliament has the constitutional obligation to establish and maintain oversight over the executive. And we believe that Parliament can, regardless of an amendment to the Disaster Management Act, exercise this responsibility within the rules and mechanisms so established and can do so without interference of impediments from other branches of government. It is therefore rather a question of how Parliament oversight can be strengthened using existing rules and mechanisms than furthering the debate on how fundamental the amendment of the Disaster Management Act is to the establishment and exercise of oversight over the executive. That means the rules are already in place. It's just a matter of looking at how to enhance the application of the rules. It must also, honorable members, be considered that whilst lessons can be learned from the management of COVID pandemic, and indeed other disasters, if we have cited other disasters, even now, the current seasonal floods and storms have been classified as national disaster and not yet declared. So that should also be our preoccupation. But we are also saying the amendment of legislation should not be the first line approach to strengthen oversight of the executive as the measures in the rules of Parliament, and the Constitution should be the first approach taken to address any possible oversight weaknesses. Now, on the question of desirability, Honorable Chair and members, we state that in general, the principle is adopted that government is always amenable to the improvement of legislative measures as a learning government, as a learning country, as a learning organization. It's always amenable to create a just, equal, and open society. However, in coming to that conclusion or decision to amend, one must also, in the consideration of the desirability, also consider whether the amendment bill was the result of broad and inclusive review aimed at identifying and including other measures that may exist. As we said, there are other measures that exist in dealing with the Act. The thrust of the Act is to deal with prevention, preparedness, and mitigation. Perhaps that is where we should spend a reasonable amount of time to say how many disaster plans are in place and how many are being implemented, and the budgets for that and the institutional arrangements within all the sectors. We now have in the region of 140 plans that have been deposited to the center, but their implementation remains a challenge in some of the sectors. So basically, we should do all this in order to improve the provisions and implementation of the Act in totality. So the following consideration, honorable members, we will submit them as requiring a broader analysis to be completed first to inform the decision on whether the proposed amendments are adequate to respond to the issues identified. So those are the issues that we recommend should be considered. That firstly, frequent non-essential amendment of legislation is not advisable or desirable. Secondly, the measures put forward in the proposed amendments may not be adequate in terms of the broader review that may be required. Thirdly, the inputs made by stakeholders, known lessons learned from disasters of various typologies, and the uncertainty of whether a broad, inclusive review was conducted to inform the amendments, it should be one of the considerations. We therefore, in conclusion, through this 3 slides, state, Honorable Chair and members, that ECOC and through the broader COCTA maintains its view that the minister, in the case of a national state of disaster, the premier in the case of the provincial state and council, in the case of municipal state of disaster, are sufficiently empowered by these sections, respectively, to make regulations, bylaws, and directions in order to achieve the objectives already stated in the Disaster Management Act, depending on any circumstance that or scenario that will have to be dealt with. We also state that the courts have also found that the assignment of these functions is constitutional, functional, and that sufficient mechanisms exist in the Act, the Constitution, and within other legislation and within the structures of Parliament, provincial legislatures, and Council to perform adequate oversight on the work of the Executive. Also, that this structure should continue with its ordinary functions to scrutinize the Executive's application of its delegated powers to help ensure that legislative measures implemented are in line with the rule of law. The issue of rationality, reasonableness, and procedural fairness. And therefore, DCOC reiterates its view that the proposed amendments will significantly hamper the efficiency of taking action when needed expeditiously to advance the objectives listed in Section 27, which experience has shown is most often required in the initial phases of disaster to bring about the required interventions. In this regard, honorable members, the existing 3 months initial validity period of the state of disaster, we are convinced, enables the Executive and the administration to focus its attention on immediate relief and rehabilitation efforts. How these aspects are to be augmented and how these aspects are to be augmented using regulations and directions and to obtain the information needed to brief Parliament and so on and so forth. And as we are aware that currently the period is 3 months, but we also want to state that the Act provides that where a particular intervention can be achieved within a 3-month period or a shorter period, the minister may simply terminate a national state of disaster or let it lapse, having run for a period of 3 months. And where a longer period is needed, as it has been experienced with dealing with COVID, the minister may extend the national state of disaster. This is also applicable to the provincial and municipal states of disaster. The proposed changes to limit the initial period to less than the current validity period and to reallocate the power to extend the national state of disaster to National Assembly will therefore hamper service delivery, especially if the National Assembly is in recess or divergent views emerge during the debate. The concept of affording the National Assembly the power to extend, and I think this is very important, honorable members. If you afford the National Assembly the power to extend a national state of disaster, but retain the minister's power to terminate the national state of disaster, that might actually create a rationality challenge as you split responsibilities for achieving one objective. So the responsibilities should continue to be allocated to the Executive, and the Executive members will then account accordingly. Furthermore, in terms of constitutionality, the various court cases listed above and the legal opinion that has been obtained indicate clearly that the courts agreed that the minister, in as far as the regulations, not only acted within the legal framework set out by the Act, but that the minister also by and large applied these concepts reasonably and rationally to achieve an identifiable purpose in the least intrusive way and to be functional for the shortest period of time needed. It is also notable, honorable members, that the broad limitations the minister as the administrator of the Act imposed as a result of COVID-19 pandemic within the framework of the national decisions of the National Executive as per Section 26 of the Disaster Management Act is exceptional, and therefore it must be considered that other risks that may lead to the declaration of national state of disaster may not need such broad means to be instituted over such a long period of time. I think we all agree that dealing with COVID was an uncharted territory for most of us. We learned a lot, and we can also always build on that. So the bill in its current format and orientation seeks to alter this system in a way that may be counterproductive and hamper the speed and efficiency with which disasters should be managed, honorable members. On that note, we would like, on behalf of our minister, submit the following recommendations that the honorable committee and members and its members know the position of COPTA on the draft bill, and that the Portfolio Committee supports the considered position of COPTA that it should not support the draft disaster management amendment bill. Thank you very much, Honorable Chair and members, our Minister, and all in attendance.
Thank you very much. As earlier indicated, we will now allow, because we said we want to not just go and take decisions, check whether we are talking to each other. Do we make sense of what we are talking about? We'll now allow Honorable Hunewald some space to talk to this bill, not necessarily introduce it, but I think he has been listening. And last time when we were talking about this, talk to us before we want to engage on this matter again. Honorable Hunewald.
Thank you, Chair. Can I just confirm whether you can hear me?
Yes, I can.
Right, thank you. Honorable Chair, thank you. Firstly, I think we all agree that this amendment bill is about accountability and oversight, as been stated in all the submissions made from all different stakeholders, from the public and so forth. And that is the issue. And if I say that is the issue, Honourable Chair, I want to refer to slide 6 of the presentation we just received, and it refers to section 55(2) of the Constitution. And maybe I must just read you what does section 55 of the section 55(2) says and determines. Section 55 is about the powers of the National Assembly. And it's got a subsection 1, and that is exercising its legislative power, and it considers and passes legislation and everything, but the most important it is. Section 55, subsection 2 states the following. It says the National Assembly must, and I put emphasis, must provide for mechanisms, A, to ensure that all executive organs of state in the national sphere of government are accountable to it, and B, to maintain oversight of the exercise of national executive authority, including the implementation of legislation and any organ of state. Now, I've put emphasis on the word must. It's not whether Parliament can make a decision, should we or should we not. It is a matter of it must ensure that. Now, Honourable Chair, if I look at the presentation and the arguments, and let's accept this is the arguments from the Honourable Minister, who is a politician herself, because I will not accept the fact that members, or can I say civil servants, can come to this committee and tell us as members of Parliament what and how we should see oversight and accountability. Therefore, I accept that this presentation, although presented by Dr. Tau, that is the view of the Minister as a politician. And I strongly want to distinguish here between we as members of Parliament and the internal functioning of departments, state departments. Yes, the Minister is the political head and responsible for that. But we as members of Parliament, we must ask ourselves, do we think that we have adequate accountability and oversight on various departments? That's why we have this specific portfolio committee, and therefore you have other portfolio committees, and each and every committee has an obligation to ensure that we comply to section 55(2) of the Constitution. Now, Chairperson, if I look at the presentation, and I think if you look at the discussion of key concepts, it's actually confirming why we should look at this matter of accountability. If you look at slide 11, where it specifically refers to accountability, and if I look at that, then I can say that is exactly what it is about. Yes, we know it's everybody's business, and that the Department of Cooperative Governments plays a coordination role. But as it says, as those factors became individually and collectively accountable to Parliament, National Assembly. So it is a confirmation that when it comes to accountability, it is all the role players in that. But when I look at the argument from the Honourable Minister, and I call it the arguments from the Honourable Minister when it comes to oversight, on slide 12, it says that Parliament has a constitutional obligation to establish and maintain oversight over the executive through various means. And then it says Parliament can therefore, regardless of an amendment to the Disaster Management Act, exercise this responsibility. Now, I differ with that. And I see the words regardless of an amendment as underlined. And that's where the main difference lies. Because according to the Minister, she feels that there is adequate accountability. There is adequate oversight. And therefore, her view that regardless of an amendment, that we can still, within the rules of Parliament, ensure that we have that oversight. Now, the argument from the Honourable Minister on that same slide is actually that we should go and look at the rules of Parliament to ensure that if it is necessary that we want more accountability and more oversight, that we should actually amend the rules of Parliament. Now, Honourable Chair, Honourable Members, the fact of the matter is rules of Parliament cannot override legislation. If, for instance, a piece of legislation, like in this situation, if the Disaster Management Act determines that the Minister extends a state of disaster, then we cannot make a rule in the rules of Parliament to say, besides what, or irrelevant of what the Act determines, we make a rule to say that before there is any extension or further extension, we must, or the department must come to Parliament. We cannot do that by means of the rules. We can only do it by means of an amendment of the piece of legislation. And that's why we have an amendment bill to ensure that there is more accountability and oversight. And Honourable Chair, we have listened to all the stakeholders, well, many stakeholders and people, and even arguments from the honourable members in the committee. I didn't find one argument to say that, well, besides the department, of course, to say that yes, we must strengthen the accountability and the oversight when it comes to the Disaster Management Act. We all agree on that. So the argument from the Honourable Minister to come and say that we don't have to amend the bill, we can use the rules, is in fact incorrect. That is not a solution to it. Furthermore, Honourable Chair, I want to emphasize again, there was an argument to say, but we should look at the Act in its whole. And yes, we've all learned some lessons through this whole process, because it's the first time we actually were confronted with this situation of COVID-19, and that we should look at a comprehensive amendment of the Act in its whole Now, Honourable Chair, we must distinguish when it comes to technical issues in the administration where there were certain problems, yes, then the department must come forward and make proposals for the amendment of the Act. And that is what normally happens, that amendments of bills come through the different departments. And yes, that's where the civil servants are applicable and while they are involved to make suggestions to improve the Act. But, Honourable Chair, when it comes to accountability and oversight, it is not for the department and the civil servants to come forward and say, no, this is not going to be suitable for us. When it comes to accountability and oversight, it is exclusively the task and the views of the members of Parliament. And why I say that is that we as members of Parliament has an obligation towards the electorate and the people of South Africa. And let's be practical. All the arguments, and the main argument against the bill is that after 21 days to go to Parliament and to ask for a further extension is going to hamper the process and the ability of the department to function effectively. Now, we had that discussion, Honourable Chair. I think there were many or other members of this portfolio committee and said, but that's not true. Because it is possible, for instance, for Parliament to have a sitting. You can have it any day. You can have a recess, and if there's a decision to be taken, it can literally be organized that within a day, there can be a sitting by means of electronic means, and the speaker can do that. But having said that, Honourable Chair, we also said that if 21 days is the problem, it is for this committee to make a decision to say, well, let's make it after 45 days, or whatever the case may be. The other argument that has been used, and what I heard from honourable members in the committee, is to say, but we must thoroughly go and look, and I think it was a specific argument from the EFF, which they said that they do believe in accountability and oversight. And I said, that's the way I see the EFF. They also want it, but they have specific problems when it comes to certain issues, and they've referred to, it's only looking at white monopoly capital and all that sort of things. The fact is that this amendment bill that determines that after a specific period, that a further extension must be approved by Parliament. And yes, when it comes to whether it's a simple majority, whether it's a 2/3 majority or 60% minority, it's for the committee to make a decision on that. But when the regulations must come to Parliament, that is where, for instance, if the EFF feel that this regulation is going only to favour a specific sector of business, then they can object to it. But at this moment, there's no way that there can be any objection. So, Honourable Chair, I want to emphasize, this is an opportunity for members of Parliament to prove to the public that we take our work seriously and that we want more accountability and oversight. And let me also say, Honourable Chair, that there was also put emphasis from the department's side to show the difference between a state of emergency and a state of disaster. But, Honourable Chair, the honourable members must also realise there are quite a lot of similarities between a state of emergency and a state of disaster. For instance, both acts provide that in a natural disaster, the specific piece of legislation can be applicable. So if you have a natural disaster, according to the State of Emergency Act, the President can also use that act. And all the circumstances in terms of rapid response to a specific situation and everything, the Constitution determines 21 days. But I say again, we can be lenient. We can make it longer. But if it is applicable in a state of emergency, then surely in a national disaster, it should be, from a constitutional view, be possible to do what you have to do in 21 days. A further similarity is, and because that is one of the arguments, it says that, but in a state of emergency, the defense force, or it doesn't mention the defense force, it says that it must restore law and order. Now, I've mentioned it in last week's meeting, Honorable Chair. The similarity is, yes, in a state of emergency, the President employ the South African National Defence Force. That's exactly what happened in the national disaster. As I said, at one stage, the Honourable President employed 75,000 members of the South African National Defence Force, which is actually the whole Defence Force, because it consists of only about 72 or 73,000 full-time members. So there are similarities. But because of those similarities, Chairperson, we say that it is important that the regulations must also be scrutinized and be approved by Parliament, because that is what the State of Emergency Act determines. Because it has a severe impact on the public and the citizens of South Africa. So with great respect towards the Honourable Minister to argue, to say, but there is sufficient oversight. And the rules of Parliament can be amended if we're not satisfied. So I say again, is incorrect. And we have it also in practice. How many times did the Honourable Minister came to this committee? They've asked questions. She gave answers, or the civil servants came. But whether you agree or not with the answer of the minister, so what? She continues. There's no way that Parliament has the power to say, but we disagree with this regulation. And I refer again, and it says here in a rational way, there's no rationality in the regulation that determine that you're not allowed to use open-toe shoes. There's no rationality for that. But this committee could do nothing. They heard what the regulation is. They've asked the questions. And if the minister says, well, I think that it is necessary. So take note, members of Parliament, that I think it's necessary, and that's it. That is not oversight. That is not accountability. Accountability is not only to come and say, this is what we do, and thank you very much.
Recording stopped.
So, Honourable Chair, I want to conclude, and I want to say the following. I urge and I appeal to the honourable members of this committee, because a decision has to be made on the desirability or not. If you reject it and he says it's not desirable,
recording in progress,
then it is the end of this bill. Yes, it still has to go to the National Assembly for debate. But, Honourable Chair, I appeal to the honourable members. Let's take this matter and further investigate on this real oversight powers. there is a reference to say that the rules of Parliament can be amended. I would ask this honourable committee, before we make a decision on the desirability of this bill, let's get a presentation from Parliament on the rules, and that they come and explain to us. If I'm wrong, then I'm wrong, but I'm sure that I'm correct when I say you cannot amend rules to ensure more, or when it comes to the extension of, for instance, on the national state of disaster, that you can amend the rules to deal with that matter. And therefore, I will ask this committee to not take a final decision today, but let's get such a presentation. Let's get all the sides and all the information, because in the end, Honourable Chair, I would like to see that honourable members, and yes, we are from different political views, that's no problem, and I respect the views, but let's say to each and other that let's get this presentation from Parliament so that we can be assured that we made a proper, informative decision on this matter. I thank you, Honourable Chair.
Now, honourable members, I will be taking your hands as they come. I see Honourable Brink, you are number one. Investing you. Honourable Teza, number two. Honourable Matumba, number 1, 2, 3. Honourable Direko, number 4. Can I take you in that order? Honourable Brink.
Thank you very much, Chair. I am just going to express myself on the desirability of this bill, though I'm not opposed to the idea that we consider further information, in particular, a response to the presentation on behalf of the Minister, in which the main argument seems to be that government must be agile in responding to disasters, and that the main function of managing disasters should be with the executive, and therefore, according to this account, that this bill, which will amend the Disaster Management Act, is not desirable. With respect, I don't think that those are the issues before us, Chairperson. It's not about who manages a disaster. Of more concern is about who makes the laws, and the lawmaking function in our constitutional system belongs to Parliament. And what the Disaster Management Act and the Declaration of the National State of Disaster does is it makes an exception to the lawmaking competency of Parliament by granting the COGTA Minister and her delegates the power to issue regulations in place of what should be governed by Parliament-made law over vast swathes of life, from the sale of goods and services to the movement of people, things that really go above and beyond what should be the subject of ministerial regulations. And if people are confused about the similarity between a declaration of a national state of disaster and a declaration of a state of emergency, here is the answer. It is in the power that it grants to the executive to assume the ordinary lawmaking powers of Parliament for the duration of that declaration. So, Chairperson, the real question before us in judging the desirability of this bill is to ask what current procedural constraints are in place by way of accountability and oversight under especially a national state of disaster to make sure that the extraordinary power given
to the executive in place of Parliament is not abused? And the answer, quite frankly, Chairperson, is threefold. Under the current Disaster Management Act, Parliament cannot prevent the extension of a national state of disaster. Parliament cannot amend any regulation issued under a national state of disaster. Parliament can't even receive advance notice of the regulations that will be issued under such a declaration. We have got no real formal oversight powers, even as the power of Parliament is usurped for a period of time that depends not on Parliament. It's not Parliament who decides how long this declaration will be. It's the executive, whether the minister herself or in consultation with her colleagues. That leaves Parliament with very little real oversight powers. Now, the claim has been made that the courts have already decided that this legislation is constitutional. Well, those are High Court and I think in one or two instances, higher court decisions, but the Constitutional Court has not been in a position to decide whether Section 27 and the extraordinary powers exercised by the executive under a national state of disaster is in fact constitutional. And an appeal in this case, in one of the cases cited in the presentations made on the minister's behalf, is currently waiting a judgment by the Constitutional Court, which makes that point rather less persuasive than just to make a general statement that the courts have already decided. They haven't. So, Chairperson, lastly, let's consider what this bill before us will do to limit the agility of government to respond to a disaster. It will not prevent the minister from declaring a national state of disaster. It will merely require her to seek the permission of Parliament if she wants to extend it. It will not prevent the minister from issuing regulations under a national state of disaster. It will merely give power to Parliament to counter those regulations at a later time based on unfolding circumstances. This bill will not put government in a straitjacket or make it less agile. And as the point has already been made, it's such an obvious point, one wonders why we should make it. Parliament can be called at any time to make the decisions that this bill proposes to put in the domain of Parliament. So, Chairperson, I think that a compelling case exists for this bill to be regarded as desirable and for us to consider the different provisions of the bill clause by clause. This is not a practice of continuously tweaking with legislation. This is an important time for us at the end of the worst of this COVID-19 pandemic to review this legislation, to decide whether it's constitutional, whether it is fit for purpose. And let's use this opportunity because it is clear that the review of this legislation is not going to happen at the initiative of government and of the minister. Thanks very much.
Thank you, Honorable Feza.
No, Chair, let me begin here. Section 92 of the Constitution on accountability and responsibilities, Section 92(2) then says members of cabinet are accountable to collectively and individually to Parliament for the exercise of their powers and their performance on the performance of their functions. Members of the cabinet must act in accordance with the Constitution and provide Parliament with full and regular reports concerning matters under their control. Now, there is a greater ambiguity that we questioned the last time we were here and that some of the proposals that the member is proposing are not bringing, for instance, as to how such communications and such sourcing of funds and such issues pertaining to line departments, how are they going to do them within the proposed time? That's first and foremost. And they are not able to give us, secondly, out of the 500 that they are talking about on WhatsApp, the communication from which determines how many people did submit and how clear were they in terms of the desirability of this bill. I'm not able to point as to how much of that were from the community, just apart from the stakeholders that came here, which some of them we questioned their position on transformation and other to the transformation of society as required by the law. And as such, Chair, we went on to ask the department in our last meeting as to whether there are measures to run the state of disaster are indeed proactive. In that, if you take the case of Lady Smith, where there are floods, you'd find out that the department is not able to have implements or instruments to suck out the water that is caused as a result of a disaster. And the fact that, Chair, you have that situation where we are not cleared on many aspects, it actually says that there is a lot of mimicry that's going on. They are proposing a 60% simple majority to then go to Parliament and vote on these matters. Our view is the same, Chair, on that we are not quite convinced in terms of what they say there as to how the process will unfold to give rise to the 60% that they are proposing to then deal with disasters. And then we of course spoke to their monthly extensions after 21 days and things like that. But Chair, we're still not convinced that this is quite desirable on those bases that some of the people that came here, not all of them, are quite questionable in terms of their interest in this bill and their status in society in terms of the privilege. I know that last time I was asked to use my brains, and this is what I'm trying to do. This is not we are doing. We are informed by the tools of analysis, by Marx, and by Fanon, by Lenin, in terms of the analysis of society. And every time a whites-only representation comes, we don't look at it from a point of view of it being genuine, but we look at it from a point of view of privilege in society and as to what do they need, these people coming here, because they have everything. So I do not know what the need is, whether it's self-seeking need or it's societal need. So for me, it's society, and that's where it ends. and how many people were consulted in society? How many of our people are aware of these amendments that we're making here? Apart from a perceived the perception that we have that those stakeholders, those proposals, those who are proposing actually represent a certain society. So, in reality, we do not think that it's convincing, Chair. We reject. Thank you.
Thank you, Honorable Matumba.
Thank you, Chair. Chair, I think listening here that we have to understand that there is something called separation of powers. We must not find ourselves wanting to be the executive and to do work of the executive. We must do work of Parliament and allow the executive to account to us and allow ourselves to do oversight on the executive. If we want to be ministers, we must go and be ministers and not want to be ministers as members of Parliament. Chair, I will invite you to the part of the Constitution that in this presentation we got on page 6. Page 6 speak of section 55, 56 and 57, but then section 52, subsection 3, which clearly states that the National Assembly is elected to represent the people and to ensure government by the people under the Constitution. It does this by choosing the president, by providing a national forum for public consideration of issues. And listen to this one, by passing legislation and by scrutinizing and overseeing executive action. Now, if we are to speak of overseeing the executive action, then it then takes us to the presentation that was made, takes us to section 55, subsection 2. Now, if you are to read section 55, subsection 2, it's clear. It says the National Assembly must provide mechanisms to ensure that all executive organs of the state and in the national sphere of government are accountable. Now, what are those mechanisms? Those mechanisms, if you are to read chapter 3 of a document called Oversight and Accountability Model, Asserting Parliament's Role in Enhancing Democracy, it will show you that those part of those mechanisms that are existing, it's Parliament committees, it's us. They account to us. So to say there is no accountability and oversight, it's not true. It's there. They fail us by those who are to do the work. Doesn't mean that mechanism that do not exist. And the mechanism that exists is there in our own constitution. So I have to agree with the latter speaker that we do not support the amendment based on the Constitution of South Africa, because the Constitution gives us enough powers to do as Parliament to do oversight and for them to account on us. So to add more, it will be to want to be the executive. Thank you, Chair.
Thank you. Honorable Direko.
Thank you, Chair. Greetings to honorable members and department under the leadership of the Minister Menkosazana Dlamini-Zuma. Chair, when you listen to the presentation from the department and the on this issue of the Disaster Management Act, you'll realize that when you look at the bill, it's got three perceptions. The first one, it says, Disaster Management Act of 2002 does not currently provide adequate legislative accountability and oversight over the regulation published in terms of it. And then it says the duration of the state of the disaster must change. And when they say it must change, they then said it's either the Parliament, the legislature, or the council must fit, and there should be a certain number of members or councillors who must form part of that sitting in order to take decision on the issue. And I don't believe it's really desirable to support this bill. Reason being is that it mostly speaks about oversight and accountability, which is covered in our constitution as to who's the responsibility of Parliament, who's the responsibility of the executive. So I believe that there is provision for oversight and accountability. Maybe what needs to happen is to say, is Parliament, to be precise, the committees of Parliament fully exercising their roles and responsibility? Are they performing in that? Because they are the ones who are responsible for playing oversight and accountability to make sure that there's an accountability. And then maybe what we need, and then Honorable Zade, he was also raising the issue about the disaster, the current disaster management that we face in our country. Maybe what we need to do, we need to also deal with is to say, how do we strengthen the current Disaster Management Act, and how do we make sure that they are implementing on what they are supposed to do in handling the disaster? However, Chair, and when you look at the people who are supporting this bill, then you also question yourself, because remember, despite being the members of Parliament, you are also politicians. When you look at the pattern of the people who are supporting this bill, you then ask yourself, is this bill going to assist majority of the people, or is just mainly made for minority of the people? And when you look at other matters, they are there, but they really doesn't make sense. When you speak about accountability, does having a Parliament of 60% agreeing on the days of the state of disaster, does it mean that it's accountability? Does it mean that it's an oversight? So I believe the current status quo is working. And what we'd rather do is just to take lessons from the current situation that we've been, improve on what we've felt that it was a weakness on our side, and support the current status quo. So it is not desirable, Chair. Thank you.
Honorable Mbomza.
Thanks, Chairperson. Chair, let's appreciate the initiative of Dr. Groenewald to propose this private members bill. However, Chair, what the bill seeks to objectively achieve runs contrary, one, to the provisions of the Constitution, particularly Section 55 and Section 92, where the power to oversight and to account originates in the Constitution. The power of the Parliament as well as the power for executive to account. Chair, Section 27, 41, and 55 of the Disaster Management Act empowers the member of the executive, the premiers and the councils of municipalities to make regulations. And therefore, sufficient oversight mechanisms do exist for structures of parliament and provincial legislatures and councils to perform adequate oversight and accountability over the executives. Furthermore, Chair, this very act, the Disaster Management Act, on the same Section 41 and 55, they continue to, Parliament has delegated regulation making powers to the executive, so that they are able to be in a position in a disaster situation, begin to work towards developing a capability in the structures of government, so that they might be in a position in an agile form to reduce and constrain the vulnerability of that part of the to the lives of the people, as well as the danger to the economy and the structures, the property of the country. So it is therefore, Chair, to me, strange that, because I know that Parliament cannot legislate in advance in ways and means to deal with a certain unforeseen calamity. And therefore, to me, there is no compelling reason that makes it the desirability of this amendment to arise. Parliament has oversight mechanisms in terms of these legislative prescripts. And therefore, Parliament is able to, has provided that in laws and in the Constitution. We cannot now override the Constitution by going to amend within a legislation, at least to ensure that, to say that, no, there is no accountable. We want to put in this particular act some form of oversight and accountability. Oversight is happening. And it is in our ability of the portfolio committee chair to call the minister and the department to account at any time. In what form then that would make the executive account if we have to go and amend the regulations? You see, regulations are a secondary legislation that is supporting and enhancing the implementation of the act. Ours remains within making the law. We've made the law the Disaster Management Act. And then as custodian of that law, we have to work it. How is this being implemented by the executive? We can't go beyond and say we want now also to legislate on regulations. And the chair, these regulations, they had been put into test currently through this pandemic. They had been put to test in the course of law. Whether indeed are they reasonable or whether are they not being arbitrary. And the courts had found no unconstitutionality, no irrationality on these matters. Therefore, this does not give us compelling reason to say we need to amend. We appreciate the initiative by Dr. Hunevart, but we maintain and we are convinced that indeed the mechanism to oversight, they to exist and they are adequate. And there is no compelling reason to look at amending that is the Disaster Management Act in its current form. I thank you, Chair.
Thank you, Honorable Kalipi.
No, Chair, I think I'm partly covered by the latter speakers, Chair. Let me not repeat what they have been said already.
Okay. Thank you very much. Honorable members, we were supposed to conclude the business on this item today by taking a decision on the desirability of the bill. Well, Dr. Groenewald, when he was speaking, he still thought there is need for more information. But we thought would allow all the members to go through this. So I think now, Honorable Mbumza, you must unmute, yes. So I think we have come to that stage now where we must decide on the desirability, noting what Honorable Groenewald said. Can I get somebody to move that we must do this? This is how we must decide on the matter. I don't know how to count who says what, but I think in terms of the numbers that we have as a committee, we should be able to say this is the general view that must prevail now in the committee on desirability. I think we have spoken now. I think everybody has been taking notes. Secretary, can you guide me in terms of, I know that there are members, there are alternates, and there are all those people. Honorable Groenewald, you want to say something?
Yes, thank you, Chairperson. I want to propose to the committee that, as Dr. Groenewald also said, that we get a presentation from Parliament in terms of the rules of Parliament. If we can get a formal presentation from them, that will assist. Thank you, Chair.
Yes, is elaborating on that proposal, taking that into account as well, members. I want us to decide now whether we postpone the decision or we decide now, postpone it on the basis of this request. Any takers?
Chairperson, that was a proposal, Chair.
No, your proposal was saying, why not ask Parliament to take us through the rules as to whether we can. In fact, I will not be like you. I know what you wanted to check whether the rules can be used to strengthen accountability. But I may not present it the way you presented. You want to repeat that?
Chairperson, if I can then reformulate the proposals to say that we postpone the meeting until such time that the presentation can be made, if that will assist.
I think members are listening, then they are noting that. Can I see hands? That takes us forward now in terms of this.
Chair, if I may come.
Honorable Mkalipi.
I just want to check here with the Secretary of the Committee Chair, or maybe our researcher can also help us. When are we expected to deal with this matter as a committee? Because I know in the programming committee we're expected to give an update. What is the deadline so we can consider the proposal of Honorable Funevar?
Recording stopped.
I am the one who should be saying we don't have much time. I sat in a meeting where we were given this bill to say it has been tabled before us. It has been with us for quite some time. And we said within 2 weeks we'll be done with this thing. I was hoping that this meeting will decide on the matter. So I did sit in a meeting where we were told it's one of the urgent issues we must finalize.
Honourable Chair, if I may.
Yeah.
If I may assist on the last question, Honourable Chair. In the presentation from the Honourable Minister.
Recording in progress.
It stated that the rules of Parliament can be amended and can be then adequate to deal with the situation, which I disputed. It's a fundamental issue because the Honourable Minister makes a statement which I don't think is correct. And that's why I said that we should get a proper presentation from Parliament to see whether it is possible. Because if it is so, then we can look at the rules and yes, but if it's not so, then there was a point made or a fact, well, it's not a fact, but it was put forward as if it is a fact to deal with this problem we have. And that's the whole essence of the bill. So that is why I said that that is what we should do and made the suggestion.
My fear with this discussion is that we might be quoting the issue of the rules out of context to start with. I think the rules were cited as part of explaining what Parliament is about when it talks about accountability and oversight. And I think that's all. As a committee, you are an extension of Parliament. So the rules that apply here, I'm not sure if that would be the context that they were trying to say we can amend the rules in order for us to be effective in doing oversight. I don't think that was the point. I think the rules were cited as something that must strengthen what is in the Constitution, what is in the law, and it must never, in fact, that's not possible. There's no way that the rules of Parliament can actually take into account what you were proposing. But like I'm saying, we didn't want to push, like I'm saying, we want a common understanding in terms of what we want. We all want oversight, we all want accountability, and everybody agrees. The laws of the country give us that authority. First law is the Constitution. Nobody is disputing that. I think even the minister is not disputing that. You see, what came out of this for me is where Parliament, when it promulgated this Disaster Management Act, the current one, delegated its authority to pass regulations to the executive. That's what I think Honorable Brooms raised that in terms of Section 41. Because I thought that was the issue. Who is passing regulation? On what basis? We make laws, and I can pick a sense that amongst some of us, there's a view that says regulations as well. But now, in the Act, it says it has been delegated. It has been assigned to the executive. So in that context, of course, if that was the issue, then that becomes, so in other words, the issue of regulations, I don't believe that regulations would come anyway in terms of dealing with accountability and oversight. But again, we don't want to push a decision because it will help us if we have a common understanding of what we do as Parliament. So if you still believe we must still get more information, and members agree to that. So I'm still looking for hands, but I think it's the last hands now.
No, Chair, I will propose that, let us just decide on this item today, because I think you are quite correct. When the department was citing the issue of the role, it done so under oversight. I can even read what it said here. It is therefore rather a question of how parliamentary oversight can be strengthened using existing rules and mechanisms. And I fully agree with you, Chair. There's no specific rules that speaks about disaster management. The rules of Parliament specifically cover the aspect of how the members of Parliament and all other sittings of Parliament, but not specifically the committees. So I don't think if we can invite the Rules Committee to come and do presentation here, they can zoom in on what we are discussing here today. I think you are quite correct, Chair. We are going to waste time. So let us decide on the matter. If we want to support the issue of the proposed bill, we must do it rather than diverting and want to invite people who are irrelevant to the debate on the item that is being on the debate today. Thank you, Chair.
Honorable Direko.
Thank you, Chair. I also support Honorable Mkhaliphi, Chair. When you look at our program, we've got a lot of things that we need to do. And I believe that we had several sessions on this bill, and we need to make a decision and move on to other matters. As you all know that we are approaching the end of the first quarter, and we need to deal with all the bills that have came into our attention. So I think it's better that we make a decision now and close the matter once and for all. Thank you, Chair.
Okay, honorable members, it looks like, because I was asking the secretary, I think the general view now is that the motion is not desirable. This bill, the desirability of it is not approved. Listening to what members are saying, I was asking the secretary, who are the voting members of this committee? She has given me a message that says those who qualify now, who are present in the meeting, are 9. So I am not sure, Honorable, I saw some hand. So there are 9, and it looks like 5 are saying we must go ahead and say this is not desirable.
Chairperson, if I may.
Yes.
Chairperson, can each member of the committee then just indicate how they are voting, except for, rather than you make an assumption to say that there's a majority, so we can vote person for person?
No, that's correct. That's a good proposal. can I get indications as to how members are voting, or just note them as they indicate?
I'm not in support of the bill, EFF.
Not in support, Honorable Mkalipi. Yes.
Not in support, Chair. Honorable Chaza.
You are not voting, Wena. I'm the only one who's voting here.
Oh.
Okay. Honorable Brink.
Chairperson, I and the Democratic Alliance are in favor of the motion to consider this bill. In other words, we find it desirable to consider it and to move on.
Yeah. Honorable Direko.
Chair, as members of the ANC, we are in support of Honorable Mkalipi. This bill is not desirable.
So are you going to, are you doing it en bloc, or because I thought we are taking hands now?
Myself and Honorable Mkalipi are speaking on behalf of our political parties, Chair.
Oh. Honorable, what is the next one? I am looking for hands. Honorable Groenewald.
Thank you, Chairperson. Myself and the Freedom Front Plus is in favor of the desirability of the bill. Thank you, Chair.
It looks like my summary, except that the political parties are not telling me. When you say yourself and the FF Plus, I don't know how many you are who are members of the committee. That equally applies to EFF and ANC. Honorable Brink, is that an old hand?
Yes, Chairperson.
Okay. Honorable Spies.
Yes, Chairperson. I would like to vote as the member of the Democratic Alliance that this is the amendment is desirable. So we support the amendment. Thank you.
Okay. Honorable Direko.
Chair, I think it's an old hand, but I was saying in the ANC, we have 5 members. It's myself, is the chair, it's Ntate Mpumza, it's Honorable Mamkize, and it's Honorable Kibi, who is an alternative for Honorable Becky Hadebe.
I see Honorable Mpumza. Oh, you are dropping it. Honorable Mkalipi, how many are you from the?
Yeah, Chair, we are 3, of which I'm the only one who have, in terms of the rules, who have powers to vote.
Right to vote. Okay. Honorable members, the majority is saying this bill is not desirable. And, on the basis of that, we are going to, I think, look at all the proposals that came out from here to say, in essence, when you talk about amending legislation, this should be an ongoing process. Our engagement was not fruitless. Our debates and discussions can never be fruitless. They are coming from experience, from the ground as members of parliament who are public representatives. Their views that we got from the people, so they can never be ignored. But those who have got responsibility and the capacity must, you see this idea that says, if we do not move on with the bill, it means everything that we have been talking about here, it remains here. That should not be the approach. The approach should be to say, we have discussed this matter as members of parliament. And I think the executive has had us. They had to listen to us. We also had to listen to what they are saying. And legislative reviews, it's an ongoing process. And let's assume that what we have been talking about here will not just be thrown into the dustbin, but let's allow a process that would begin to say we have taken into account a number of other issues or areas that must be discussed if we talk review of a piece of legislation. And I think in both sentiments we have received that, something that says, yes, of course, this COVID-19 was something new, but there have been many other disasters before. Even this piece of legislation, we are actually testing it, whether it does address some of the issues that confront us as we proceed. And as we test it, we are learning, and those given responsibility as well. So hence one would be saying the sentiments expressed by Honorable Mpumza to say Honorable Groenewald must be thanked for putting all the effort into this piece of legislation, the bill itself, and the discussions, the engagements. And I think it is not something that can just be thrown away and we say we don't think it was worth doing. But I see Honorable Groenewald, you want to say something?
Thank you, Honorable Chair. From my side, I also just want to say thank you for the opportunity. I understand the dynamics of politics, but I also want to thank all the stakeholders who made from the public, who made submissions. I also want to thank Mr. Michael Prince from the legal department from Parliament who assisted me with this bill. And thank you for the honourable members, for specifically those who supported the desirability. It is your political right, of course, of other honourable members to not support it. I respect that. But may I just ask, Honourable, also for you, Chairperson, it actually started with your predecessor, Faith Mutambi, who was chair at that stage, who started the process. So thank you from my side. But can I just, to make a point of certainty, Chairperson, I do believe that we have and will have a proper minutes on this specific voting to see which members specifically voted against or for that. And it's not a threat, please understand me, but this may go to the Constitutional Court because all the court cases that had been referred to, as it was also said, none of them went to the Constitutional Court. So I just want to make sure from an administrative point of view that we do have proper minutes on the meeting. Thank you very much, Honourable Chair. And the
Thank you very much. Thank you very much, Honourable Groenewald and honourable members. We think it was something important that we should finalize on the matter. And I think the message is clear from those who are writing minutes and all that. Thank you very much. We are running late now for Parliament. The meeting is adjourned. Thank you.
Thank you, Chair.
Thank you.
Thank you, Chair.
Thank you, Chair.
Thank you.
Thank you, Chair.
Thank you, Chairman.
Thank you.